ಮಾಡಿದ್ರೆ ಆಗುತ್ತೆ.
ಓಕೆ.
Lordship, serial number 33. I'm for the petitioner, Your Lordship. Senior is unwell today, Your Lordship, seeking for a short accommodation in that matter.
Whenever you.
Any day, in April first week or second week.
Third April.
Interim order may be extended in that.
So if there is no urgency, then let it go.
There's no.
No urgency. After summer vacation.
Yes.
Other side is no objection.
We have tried contacting them, but we couldn't get.
Then contact.
Any date is
21st of April. Interim order to continue. Will be next week.
Your Lordship, serial number 27. I'm appearing as a proxy counsel for respondent number 5. The counsel is seeking time to file objections. We have informed the petitioners in that matter, Your Lordship.
PIL.
27 serial number.
You are sitting.
Respondent number 5. We have to, respondent number 5 was to file objections with.
21st of April.
My lords, two mining matters. They were previously listed on 21st February. Date given matters. On that day, it could not be taken up due to paucity of time. The next date which is given is, my lord, is on 24th March. My lord, there's slight urgency here for the petitioners. What happened is day before yesterday, the petitioners' assets on that mining area, they are in the process of being seized. That's why the urgency. We filed an application for advancement this morning. It may be taken up tomorrow, my lords, please.
Advancement application will be posted on Monday.
Please, my lords.
My lord, serial number 17 and 22. Senior has some inconvenience.
17.
17. We are for respondents in serial number 17.
If no urgency, then after summer holiday.
Kindly have it in next week, my lords.
23rd April.
And 22 also, my lords.
22 also. 22, 24th. There is a delay. Delay. All 24th.
Grateful, madam.
27, I'm for the complainant, madam. Lordship, may kindly have it on 27th, madam.
27th March.
March. Hello.
10/3 of 2025. Custody matter, my lordship. With for order, my lordship. That is Honorable Court given to permit to written order. Supreme Court. Custody matter.
You are on whose behalf? On whose behalf you are? You are on whose behalf?
Petitioner.
It is.
Already served copy, list of events and synopsis of everything filed, my lordship.
Petitioner Ms. Jaina Kothari. Jaina Kothari.
My lord, serial number 24. I am for petitioner, my lord. Kindly have it done next week, my lord. Serial number 24.
Twenty 8th of April.
Please, my lord.
55. You have for opponents. 55.
50.
For opponents. Number 4, 5. I for vacating. I need to file objection. Kindly.
It can go after vacation. 10th June.
April.
10th June.
Serial number 21. May seek a short accommodation government interest of
21.
the respondents. 21 months.
All right. When do you?
Anything, my lord.
Then go after 11th June.
Serial number.
May I request for an adjournment in serial number 28, my lord? And for the impeding respondent.
That
need
is
to file
PI,
the document.
PIL.
Please, my lord.
No objection. When shall we keep?
Any day.
23rd of April.
Serial number 98, my lord.
Interim order shall stand extended till the next.
Even 98.
98.
Petitioner may be permitted to 98.1, my lord. Withdraw the petition. Petitioner may.
Both. No, it is PIL. What is it about?
98.1.
It is at 2:30. Come at 2:30. Live.
Withdraw the 98.1 with regard to
98 also.
98.1. 98 is filed by the government. Nagaraj.
Oh.
only 98.1, my lord, I am representing the petitioner. They want to withdraw the petitioner.
Then you give the papers. What is the matter? What is the subject matter of the public?
There is a, with regard to the construction in the premises, my lord, the illegal construction, they do not want to press their petition.
Why?
All the grievance has been met. That is what the petitioner informed.
So every withdrawal of PIL will impose cost. Because you file with some other motive, withdraw with some other motive. Yes. Give it.
There was a land on Sopin Betta.
With the memo. The memo is filed dated 12th March 25 on behalf of the petitioner, which is signed by learned advocate for the petitioner as well as both the petitioners. So why it is not filed by other petitioners?
There are only 3 petitioners, my lord. The petitioner number 1 is represented by petitioner number 2 and 3. Petition number 1 is represented by petition number 2 and 3.
In what way represented?
They are the president of that association.
No, the Sheshagiri, Narayan Swami, Bhaskar, Ramchandra, all are individual.
No, I mean 19393 of 2011.
19393. 19393. अच्छा, okay. Come on, 17. 17 truthers will not readily permit you to withdraw without any reason or will impose cost. With this business of filing and withdrawing is rampant now, yes. What is the urgency? Pardon? What is the urgency? What is the urgency? Contempt petition? 28th of April.
Any convenient date.
What is the urgency?
There is no urgency. Convenient.
Then it will be listed. Wait for a week. Then mention again.
My lord,
Remove the office officer and they will be listed.
my lord, serial number 69, 70 and 71, we are filing for withdrawal of the petitions.
69.
69, 70 and 71.
Learned advocate Miss,
Sorry, my lords.
what's your good name? So instance of files memo. They are connected appeal, connected petitions.
No, my lords, it's similar matters. It's similar matters.
They are connected. It at 12/3/25 seeking to withdraw the present petition. Permission is granted. Petition is dismissed as withdrawn. Same order in all three. 68, 16. 68, 16 and 70. Right.
My lord, 69, 70, 71, all three petitions.
And 71.
My lord's memo, inquiry has been conducted violation of the
Yes.
order which is passed.
70, some other advocate's name is there.
Madam,
70, some other advocate's name is there.
My colleague only, my lord.
My lord's memo for inquiry which is violation of the order passed by this honorable.
My lord, serial number 62. My lord, the council record is in Dharwad today for the matter. Kindly an accommodation.
pardon.
My lord, serial number 62. My lord, the council on record is in Dharwad today for the matter. So kindly a short accommodation for the same.
Beyond summer holidays. 16th June.
Serial
Number 80, the matter is listed for office objections along with counsel submission. My lords, the urgency in the matter is that an order has been passed by the trial court vacating the interim order granted in favor of the applicants. We have the necessary certified copies to produce for crossing of these office objections. My lords, the matter may kindly be posted for preliminary hearing.
What is the objection?
80. Serial number 80, my lord.
What are the office objections?
My lord, certified copy of gift deed and certified copy of the interim order.
Then file it. If it is,
File it through the course of the proceeding. During the course of the proceeding, we file it. We have.
first you file,
serial number 9.
not course of the process.
My
Yes.
lord's memo for posting and inquiry has been conducted according to the violation of the order which is passed by the.
Pardon?
Memo. Inquiry has been initiated, which is violating the direction which is passed by this honorable court.
So what is that?
My lord, inquiry has been conducted by the.
Appeal, what is what?
Yes, sir.
What you want to post, which matter? It is appeal, petition, contempt, what is, what is the urgency?
The inquiry has been initiated, which is violating the.
No, you wait for, remove the office objection.
Serial number 96, my lords, state appeal. Prays for 2 weeks time to file a better affidavit pertaining to condemnation of delay.
96.
96, my lords.
96 meant somebody mentioned or?
No, 98 it was.
Achha, 96. So you want time?
2 weeks time, my lords, to file a.
Let it go after now. June, 11th, 12th June,
Contempt, the contempt at serial number 37, may have all,
37.
37, may connected with the
Go
appeal.
to 12th June. 37.
Please, my lords.
Can you mention through VC, sir? Contempt matters, till number 1, to Mahesh Arupit.
If the other side has filed an affidavit saying that they have complained, in fact, there is no complaints. But the note is passed, not directing the government to initiate proceedings under APIT Act. No notification is issued to attach properties of only one person. There are 7 other directors, not. They have not borrowed money from the very same society to the tune of 28 crores. No steps taken by remaining directors. And after issuing this notification, they are required to appoint competent authority, and competent authority has to file application within 30 days from the date of notification for confirmation of attachment. Nothing is done. This is not a compliance at all. I will file my objection. I will file my objection to the affidavit.
My lords, post the directions of the writ court, 28 properties were attached, my lords. Notification was issued, as also the same was gazetted, my lords.
Only one director, this was done. There are 7 other directors who have borrowed 28 crores. This is a scam of 150 crores. Many of the depositors lost money, or retired persons who invested the amount in fixed deposits to get interest for their maintenance. 150 crores. Government is not taking any action, not serious action in their class. In fact, I made a representation not in showing that not there are other 7 directors, they have, as per the audit report, they have borrowed 28 crores.
One copy is only. I have record.
Then the second
I'll
set,
file the second set also.
file a second.
Apologies, my lord.
File a second.
Meanwhile, and my objections to the affidavit.
By default, you are getting time. All right, when you will file?
By next, 2 days. time,
Third
I'll
of,
file it.
23rd April,
Very-
within which time the second set of the affidavit in compliance will be filed by the respondent. Yes.
So number 2, Stacy Butt for a complaint. The order at annexure G, page number 71. The relevant page of page number 77 and 78, para 10 and 11. But the award is supposed to be passed, my lord, for 23 years, awards have not been passed. Every time for some reason or the other, it is being postponed.
Notice
By-
returnable on 24th April.
Number 3.
My lords, I appear for the complaints in this, my lords. This is a contempt arising out of a non-commercial mandamus, writ of mandamus of the RERA orders. On the previous date also, I had made a submission stating that accused number 4 is the largest defaulter, my lords. The state has been, they failed to ensure that any kind of recovery, my lords. This is a data submitted by RERA. Close to around 650 crores is due to the home buyers till date, my lords.
What is the direction?
Direction is to the accused number
Recovery.
my lords.
Notice returnable on
My lords,
9th June.
Number 4.
similar matter, my lords.
Number 5.
Appear for the
Vijay
complaint
Kumar?
in this matter, my lord. Complaint is before this honorable court, my lord, non-consideration of the order passed by the division bench of this honorable court, or which is at page, annexure A, page 13, my lord. There is a delay of about 177 days in preferring the contempt petition. There is due to, my lord, that the communication is made to the authorities concerned, my lords, bringing it to their knowledge about the judgment passed by the division bench of this honorable court. They kept communicating intercept and they did not pass any order on the judgment passed by this honorable court. Lord, it matter relates to selection and appointment to the post of civil constable, my lord, in the police department.
Notice written 22nd April.
IA for condonation of delay maybe.
There is no delay in this country. Either it is maintainable or not maintainable.
Please, me.
Keeping the aspect of maintainability of the petition open, notice written.
Grateful to you.
So rate appeal matters. This is number 6, state appeal.
State's appeal, my lords, this pertains to 5% relinquishment. It needs to be tagged.
There is a delay. Notice returnable on. It will go to 13th June. Which is connected. Listed today. So then remove the office of the.
Yes. Number 7,
For the appellant, my lord.
Sharat Kumar.
Appellant, my lord, his father filed a petition, my lord, for occupancy rights under section 45 of the Land Reforms Act. There were, my lord, altogether, my lord, 4 properties. The Form 7, my lord, was missing. 3 times, my lord, it went and back and forth. Ultimately, my lord, the tribunal has conferred occupancy rights on in our favor. Landowner, my lord, does not challenge it. Somebody, my lord, claiming that he's a purchaser of, my lord, 4 sites, 6 sites. I, my lord, come and filed a petition. First of all, my lord, that petition itself is not maintainable. According to them, my lord, they have purchased, my lord, bits of the property, my lord, in 1 survey number.
Only remanded.
My lord, remanded, yes, my lord. Only thing is, my lord, there are so many, my lord, observations by the learned single judge that, my lord, actually, my lord, affects us totally and irredeemably. That's why, my lord, I am before your lordship.
Will say no observation will influence. The
Only thing is, my lord, can I put it in this manner? There are 4, my lord, my lord, properties, survey numbers. Only 1, my lord, they are concerned with. The other 3, my lord, can't be, my lord, set aside or remanded. Please look at it, my lord.
This was earlier considered. No, first time coming.
It's coming up before your lordship, my lord, for the first time. Earlier, my lord, once it came, but then, my lord, I think, my learned friend had to file objections or something. Alva, last time.
The question here was, my lords, on the last occasion also that was mentioned that with regard to 1 survey number, but the question here was with regard to the genuineness of the application that was filed.
Whether
And
a purchaser, my lord, can file an appeal. My lord, please look at, my lord, 2 judgments I'll give you, your lordships. This honorable court, my lord, has specifically held that, my lord, a purchaser, my lord, has no locus to file a petition.
What was the order impugned?
Order impugned is, my lord, where conferment of occupancy rights in my favor.
No. For learned single.
Please, my lord.
For learned single judge, what was the order impugned?
That's the one, my lord. Conferment of occupancy rights.
On your favor.
Yes, my lord. In respect of 4, my lord, bits of land, 4 different survey numbers of lands. Prepared a short synopsis, my lord. My lord, sir.
matter requires hearing, my lords, if what my learned friend says. May I just submit one aspect, my lords? The remand order, we will go before because 4 times.
Give synopsis.
Please, my lord.
Give synopsis. Both of them.
Please.
22nd April.
Please.
22nd
22nd of this month, my lord,
22nd and
or next month.
April.
It can be on 26th of this month.
As your lordship,
Okay.
I mean, there's not that much of an urgency. Whatever your lordship feel, my lord, we'll be here.
26th of this month, my lords. We
All
are
right,
ready.
I'll be here. I'll be here. No difficulty.
Grateful.
Yes, number 8.
Raju,
The Santosh Babu.
Lord, this writ petition is challenging annexures C to C5, my lord. My lord, annexure C at page 41. My lord, it is, your lordship may kindly see page 41. Lord, this is issued under section 108 of KMC Act 1976 by the Bangalore BBMP. My lord, annexure C to C5 for the years 2016-17 to 21-22. But annexure D, my lord, is under section 144/5 of BBMP Act. My lord, my contention is that show cause notice, when it was issued, KMC Act in its application to the Brihat Bangalore Mahanagar Palike was repealed. The act came into force on 11/1/2021. Notice is issued on 16/6/2022. Therefore, this show cause notice itself should go, because this is issued under a repealed enactment. That is my contention before the law.
Is notice returnable on.
But annexures and they are
Yeah,
taking
quite workable, my lord.
precipitative action against me, my lord, on the basis of
Returnable
this.
on 10th June. There shall be no precipitative action till the next day.
My lordship, already I filed wakalat, my lordship.
File it.
My lordship, what happened here is, I have to at least deposit 50%, my lordship, the tax amount, my lordship.
File it. Yes.
No,
next.
no, because that is it is a mandatory, my lordship, as per the law.
File your reply point. Yes. Notice returnable on 13th June. Delay.
So number 10. Tanuja, MB.
9th, you are there. 9th.
Caveat, where the government's appeal, we have
Delay.
notice was issued.
Delay is there.
There's a delay, my lords. Notice,
The
there is a
delay.
delay of 96 days in filing.
So notice.
Notice may be issued.
Now, you know,
Number 10.
we are there on caveat.
So you are there on caveats.
Yes,
Then
my lord.
give.
Delay in ತೊಂದ್ರೆ ಇಲ್ಲ. Delay, my lords, I am not.
So IA number 1 of 25, this interim application is filed by the appellant state. You are not, all are not appearing,
My lords, the others are the town planning authority. We will sail with the government.
and same order will have notice.
In fact, we have filed a contempt, and in the contempt, your lordships have passed an order that if they don't obtain any order, contempt can proceed.
When?
Lords, that was in,
Up to what time?
Lords,
Up to what time?
Lords, it was deferred till 21/2/2025.
This order is obtained.
But this is only a note.
Contempt will be listed alone.
Contempt number is.
Serve them. We'll keep it early,
Please, sir.
24th of April.
Please.
Contempt number. Still number 10. Tanuja, MB.
That's the appellant hearing has been, the BDA has acquired the site 14 to 60, my lords. That learned single judge was dismissed only on the ground that I have not filed the application in the prescribed format. There is a delay. My lords, my substantive right cannot be denied on the ground of delay, my lords. It is my constitutional right under Article 300A. As the Honorable Apex Court and this Honorable Court has rightly held that there was some inconvenience due to my health grounds, my lords. Because of that, I was not able to file the application in the format. But I have given all the documents and the application within time to the BDA, my lords. No alternative site has been provided for me. Way back in the year 1996 only I purchased
Application
my.
was after the cutoff, after the date decided.
Yes, my lords.
2 years after.
My lords.
2 years after.
Yes, my lord. I was given the application, my lords, but that was not in the prescribed format, telling that they have denied my alternative site.
Notice returnable on 22nd April.
Please.
Still number 11. Then. Amman.
My lord, the appellant, the subject matter is this of alleged malpractice, my lord. Examination malpractice, an alleged examination malpractice.
My lord,
The
cease.
appellant hails from the state of Tamil Nadu, from the most backward community, my lord. And she is the only one of the two educated literates in the family. My lord, the grounds for this that the learned court has failed to appreciate and hence this appeal is sought for is because, one, there has been a glaring procedural impropriety, my lord, wherein the body which is not even authorized to sanction punishment has sanctioned punishment. And second, the procedural safeguards that a student is guaranteed under the principles of audi altum partum is not established. And third, my lord, here the severity of the punishment overrides the severity of the offense committed, my lord. And considering that she is a final year law student and for wrongful reasons that she has been punished, my lord, this appeal is prayed for. All I pray for is 5 minutes of this honorable court's time, my lord, wherein I can establish my arguments and prove how they have procedurally erred in this case, my lord. And just a month ago, single bench has given a directions also with this regard, wherein they have held that the university is not following the procedures properly, and students are coerced to sign into pre-typed documents, for which even the memo has been produced before this honorable court.
You admitted it.
Much obliged.
You admitted that you copied from the backside of the or dismissed. You admitted it. Yes, next.
My lord.
Dismissed.
This commercial appeal, serial number 12.
My lord, there's been a procedural, it's a 5 minute stance be given, my lord. Please, my lord, to contest the matter, my lord.
Yes.
My lord, here, the admission here, my lord, in the Rahul's case, which was held on January 25th, is already the case that it's a pre-typed document, my lord. There's no admission here, my lord. It's under coercive circumstances. And my lord, just drawing your attention to page number 147, my lord. Here we see that, my lord, once the copying is done, my lord, the body to authorize this is MPCC, my lord, who it's just a fact-finding body, my lord. But my lord, if you refer to page number 43, the MPCC has given the punishment, but the MPCC has no powers to sanction punishment, my lord. It is the syndicate which has to do, and even if the syndicate finds that the MPCC's finding is true, they'll have to give a notice to the petition appellant, 7 days time. And in the past cases, my lord, where the precedents had been set, within 1 month they have given, my lord. But here, after 5 months, they have given, my lord. My lord, here the MPCC committee is only a fact-finding body. Well, the syndicate is the one which takes the decision. But here, my lord, it is the MPCC itself, a recommendatory body has sanctioned the punishment. And my lord, here also, my lord, there are 3 ways of copying, my lord. If you can peruse page number 149, my lord. One is if you copy verbatim from by referring to a manuscript. This punishment that they have sanctioned holds good. Here I'm making a fair submission, my lord. I wrote behind the hall ticket, but the manuscript and the answer sheet is not tallying. So for that, there is a different punishment sanctioned, my lord, wherein you are only debarring me for 1 semester. And my lord, I have not admitted, my lord, I was coerced to admit in the case of Rahul, my lord, which is also in the memo and it was held by this honorable court. My lord, this very court has held in paragraph number 12, my lord, if I can read, this so-called confession is not on a paper and not in handwriting of the student, but is typed by the malpractice committee on which the student is signed or asked to sign. And this is a recent judgment in the month of January. Like this, my lord, there are battalion of cases against the same respondent, wherein this court time and again has held that they do not follow the procedure properly and there has been a procedural impropriety. So my lord, here because she's a final year student and she hails from the most backward community, her father is a daily wage laborer. So my lord, an opportunity be given for her, or at least if the punishment can be condoned and the sentence can be reduced from C5 to C4, 1 semester at least will remain, my lord. Here 3 things, my lord. 1, the powers The body which has taken the powers to sanction punishment does not sanction the punishment. Here, my lord, and within the same ordinance, my lord, if you can refer to page number 146 of the petition, the student must be given an opportunity to argue, cross-examine, and to take her bona fide claim. And even after she's found guilty, the syndicate will give her another notice to come and appear, and within 7 days she has to furnish. But here the procedure is not followed at all, my lord. And they've just called her 5 months after the exam. And that if you peruse the timeline, my lord, the time when she was called was when the last date to pay the examination fees was already exhausted. So they have delayed it so much that she was not even at the position to avail this honorable court's remedy. So it's a humble submission, my lord, that this prayer be allowed and she be given an opportunity to write her examination, my lord, because this has been a black mark on her character. And the fact that she's the only literate woman after her sister and the first law graduate from her family, my lord, this will be a very expensive judgment on her if this prayer is not allowed, my lord.
That's all.
That is my submission, my lord.
That's all.
Yes, my lord.
Lord Learned Advocate Mr. So and so for the petitioner. The challenge in this appeal is directed against judgment and audited 16th January 2024, whereby the petition of the appellant herein came to be dismissed as devoid of merits. Full stop. Before the learned single judge, what the petitioner prayed was to set aside the notification issued by the respondent Karnataka State Law University dated 27/12/24, whereby the what are the where is that? What are the penalty? Debarment.
My lord, the penalty was rupees C5 was the penalty, my lord, which is in page number, my lord, 145, my lord. I stand corrected, 149, my lord. The penalty was C5. If I may read, copying from manuscript, written, printed, Xerox, scale, handkerchief, etc. Page number 149, my lord. Well, I pray that it has to be C4, my lord.
Whereby the penalty was imposed, debarring the petitioner candidate from appearing in the next two available examinations, besides forfeiting the performance in the examination and imposing a penalty of rupees 500. Full stop. The allegation against the petitioner was that while she appeared in the examination for the subject of human rights into inverted comma, human rights law and practice, comma, she committed a malpractice by copying from the hall ticket which she had brought inside the examination hall, which had the writing on the back side. The petitioner, from it was alleged, copied in his paper from what was written on the back of the hall ticket. Full stop. Learned single judge, while negating the prayer to set aside the penalty, comma, highlighted that the petitioner candidate appeared before the committee and she accepted that she had written on the back, said written backside of the hall ticket and copied from it. Full stop. In that view, the penalty was imposed by the authority. Full stop. Learned single judge, after considering the facts and the aforesaid conspicuous aspect of admission on part of the student about having copied from the hall ticket, comma, reasoned in his judgment as under, comma, extracting from paragraph 6 bracketed portion. Learned single judge further relied on the decision of the Honorable Supreme Court in control of examination versus G.S. Sundar and others, 1992, 4, judgment today, SC JT 204, to highlight the principle that the principles of law cannot be weighed in the golden scales when it comes to the cases of malpractices in the examination by the student. Full stop. The aspect stands in learned advocate for the appellant are that the procedure was not followed and that the authority which imposed the penalty could not have imposed the penalty. Full stop. The aspect that the petitioner candidate admitted about using the whole ticket and the writing thereon to copy in the examination paper, stands in the forefront. Full stop. Once the candidate has accepted, all the contentions pale into insignificance in as much as, the admission will rule the adjudicatory process. Full stop. It is right that technicalities cannot be imported when by the court while considering the cases of malpractices by the students in the examination. Full stop. The scope of judicial review is extremely limited in the present case, to be stated at the cost of reputation that the student admitted about having committed the malpractice. No case is made out to interfere with learned paragraph. Order of learned single judge, the appeal is meritless and dismissed.
Commercial appeal. Appeal number 12. Mr. Pradeep Darak.
I appear for the respondent in
For the appellant.
12 and 13. That's both 12 and 13 are connected matters.
12 and 13.
Yes, I appear from Lord appellant in the 13.
Last time there was a direction to file written submissions. Our written submissions are ready.
Written submissions, we are also filing, my lord. Because on the coordinate bench had asked us to file the written sum. Really, my lord, we'll.
But these two appeals.
Yes.
Yes.
Both arising out of same section 9 order.
Section 9.
Section 9 is rejected.
Section 9 is
allowed.
granted.
Therefore, my lord.
Granted, not an injunction has been granted, restraining them from alienating or encumbering their properties for a liability of about 1,450 crores.
They are, my lord, co-signatories in everything.
No.
Shares.
My lord, shares.
Not
They are running the company virtually. There are, my lord, several, my lord, clauses which, my lord, mandate that, unless, my lord, they consent.
the
For
liability.
the appellant.
I appear for the appellant.
And other appeal is by.
Not in the companion appeal, I appear for the appellant.
So both of you are original respondents.
Yes.
Yes.
That's
So what was the dispute?
We had submitted, my lord, they had, my lord, subscribed to convertible debentures, CCDs. That, my lord, mandated that, my lord, certain clauses.
Parties are related in some way? No.
No, my lord.
No.
We are a finance company.
Convertible debentures
L&T
they applied.
finance.
Yes, my lord. And, my lord, we were to give them, my lord, an exit. And, my lord, as per the terms of the agreement, they were, my lord, given several, my lord, reserved rights. Anything, my lord, that we, my lord, even to take one step, my lord, they had to, my lord, take their consent. So, my lord, they were virtually controlling the company. What has happened is we were to give them, my lord, some exit. They themselves brought in some investors saying that, we are willing. They said, please go ahead. They don't go ahead. Thereafter, my lord, we also brought in an investor. That they don't, my lord, go on with that. Ultimately, my lord, we issued a notice saying that, it is now you will have to know the investors, are not there. Therefore, you have not accepted. Therefore, my lord, the clause, my lord, permits us to terminate that, my lord, clause. We have terminated way back in the year 2018. Ultimately, my lord, they filed, my lord, the petition, my lord, in the.
No, there is some agreement.
Yes, my lord. In
There
terms
is, my
of
lord, a very detailed agreement which captures all the.
Then, my lord,
Between you two.
yes.
And
it
the
is
promoters.
barred by limitation.
Company and the promoters.
In relation to dealing with this.
In relation
bench.
to, my lord, an extension of a loan in the form of debentures, which was given to them, which was about 350 crores, my lord, in the year 2011. And, my lord, which has now translated to 1,450 crores.
So you are
Because it can balloon, my lord.
Our claim is 1,450 crores.
You are claiming that amount.
Yes, yes. We are claiming that amount. There is a default on their part, and owing to the default.
Our pledge shares are with them. Our shares are all with them pledged.
If my lord,
I
the
can't-
value of the pledged shares is sufficient to meet the liability of 1,450 crores, it's all right. But thereafter, my lord, there's a liability that is cast on the promoters to purchase these debentures and shares. That, my lord, they failed to do. When they failed, and the balance sheet, my lord, reflects the liability even today.
My lord, they can't have it both ways. They can't claim to be both an equity holder and my lord, a lender. It can't be both. If they are an equity holder, the
you'll also
concept
hear
of
us-
offering security does not arise. There cannot be that. The only point is, my lord, what I'll just give you lots of 2-3 more facts. 2013, there's an agreement where we say in 5 years, we will give you an exit. Because these are
Will
compulsory.
give you interest.
No,
An
not
exit,
interest, my lord.
interest.
This is an exit upon the valuation of the shares. Because these are compulsorily converted. Originally,
Acha, upon the value of the debentures,
That's correct.
you gave
Because-
loan.
Correct. Because originally they subscribe as debentures, but these are compulsorily convertible to equity shares.
So how do you give loan on the basis of the fluctuating prices?
My lord,
Not
that is the point is that
There
it
is a-
bases the valuation of my company.
There is a
Okay.
particular
basis the valuation
percentage.
of my
All
company.
right, all right.
Now, my lord, what happens is that in 2018, I procure about 4 or 5 persons who are ready to take over their interest, their CCDs. They reject, my lord, one after the other, everybody. They also bring somebody. I say I have no objection. They hum and haw, think about it, and then say, no, forget it. The agreement categorically has a clause which says that if I have to give them only an offer, once I've placed a viable offer before them, my obligation to give them an exit ceases. Then the only option they have is to continue as a shareholder in my company upon the CCDs being
Converted.
converted to shares. Now what they say is, in 2018 that happened, they suppress all these facts before the commercial court. File, my lord, in 2014. My lord,
24, 24.
2024, I'm grateful. 2024, they file a petition saying, oh, see, now I've brought a sale notice against them, therefore I should be given protection, and they take an ex parte order by suppressing all these facts. We place all this material before the my lord commercial court. 2 important questions. One, to say that they're really in the nature of equity holders. In fact, there are RBI guidelines and SEBI guidelines which say compulsorily, in fact, Supreme Court judgment saying compulsorily convertible debentures are nothing but equity. All this is not noticed by the learned judge. He notices the submission, but no finding is given. Instead, on limitation, we point out and say that in 2018 and 19, I specifically say, I am discharged of the obligation of giving you an exit. That means, my lord, I ask myself this question. I may have been right, I may have been wrong. But does not the clock start ticking for him? If there is an obligation that he asserts and I deny, his right to initiate arbitration, cause of action begins then. He keeps quiet. He keeps quiet till 2024 and effectively
6 years.
restarts and re-engineers the whole dispute. Now leads urgency and Manoj takes it now.
Limitation aspect is how far relevant in section 9.
Lord, because even for a section 9, there are, in fact, it becomes more relevant.
Prima facie.
Prima facie, my lord, the court
No,
has given
first is
findings on
prima facie.
all of the contentions. The court has answered it fully. There is no question which is left unanswered by the court in a 140-page order, my lord. Every single argument which they've argued or they advanced. Fact remains, my lord, today on the balance sheet, this liability is shown as a borrowing, and it continues to be a borrowing as of today as well. To say thereafter that it is barred by limitation, your lordship's no, my lord. Supreme Court has now time and again said any admission of a liability in a balance sheet is an admission against the entire world and is an admission for all purposes. Now the court says not only that, from 2018, Lord, there are any number of admissions of liability. In addition to that, they've also said we will try and find people to take over your interest in this entire company at a prefixed valuation. There is a valuation fixed under the agreement. It's a fairly substantive agreement, Lord, which deals with all these issues. And Lordship will see from October, Lord, this interim order has continued, and there is another interim order granted asking them to disclose their assets, which they're not disclosing to the court. And none of these assets are sufficient to even meet the liability. The liability, Lord, is 1,400 crores. It is growing every day. They have not made payment of a single rupee. And today, my lord, to turn around and make a submission that, oh, it's barred by limitation. I'll show you, Lordship, on the face of it, all the documents will show that not one part of it is barred by limitation. It is simply a bogey. And Lord, I'll tell you, Lordship, what they say. In 2024, they write a letter saying, please waive the CCDs.
What is CCD agreement?
Compulsory convertible debentures agreement. Compulsory convertible debentures. Lordship being here, us, Lord. There is extensive material before your Lordship will show your Lordship the entire case as to what they have done and how, my Lord, this money has been frittered away.
But I'll show fritting away and all is a
They-
new
they are-
allegation that
they are
will
in-
not be. I don't know.
They are in charge of the entire company
We are not
virtually.
in charge.
And
Sir,
I'll
please
point out.
Where is the question of being in
Then
charge?
they need to send
It is
themselves to
Baroka
check
Power
the-
Corporation. They are running it. We hold an insignificant number of shares here.
Lord, I cannot make an expenditure of more than 5 lakhs without their permission. Those are the kind of rights they have. No lender will have such a right, my lord.
But
It's
still
only-
you have to pay.
Not only that, my lord, please be kind enough to take the company of just one page. I'll show you lordships. Page 419. This document is, my lord.
Were the debentures converted into equity?
No, it's not converted.
No, the reason is that their option to convert exists. They can convert it, my lord, after there is a window of time that the agreement provides. That if in the first 5 years, there is no exit that they choose to take.
If it is not converted into equity, it's a debt.
No, my lord. I respectfully submit that there are judgments which say that if it is compulsorily converted, Supreme Court has said that it is in the nature of an equity only. Supreme Court, my lord, has categorical. I'll place those judgments are placed before your
My lord, the balance sheet,
Therefore, my lord,
your lordship correctly pointed out, as the balance sheet will show what the company treated it as. The balance sheet shows it was treated as a debt. And it's shown as a borrowing, nothing else. To argue everything else now, I don't know how.
But even share receipts will be only in the,
No, not
my lord, in the
borrowing. I'm
liability
sorry.
column of a company in
No,
the
no.
balance sheet. That doesn't mean anything.
Not liability, borrowing.
We'll take the submissions, but not before hearing. First, we'll hear the matter.
Yes, ma'am, yes.
So that either today or it can be.
Any date, my lord, lordship's convenience.
Tell
We'll
the
argue
date,
it.
we'll proceed.
Lordship may fix it at 2:30 someday, my lord, will.
All right, whatever. Yeah, Lord.
26.
At the earliest. 26, my lord.
Yes.
All right, we'll
Can I
be here.
just make one request, my lord? Then no further precipitative steps insofar as, my lord, direction 2, which is a new direction. Page 139.
No, my lord.
130.
Page 139. I'm sorry, my lord, in the companion appeal, in serial number.
It's all right.
Lord, the operative portion, internal page 69 of the impugned order.
Yes.
I'm sorry, my lord, the page numbers between the appeals may vary.
Yes.
Direction 2, for
Yes.
disclosure of assets is a new direction given now, well, not at the ex parte stage. It is now given, my lord, after the section 9 petition.
It's only disclosure.
Precipitate.
It's only disclosure. I'm making one suggestion to my learned friends then. Let them, my lord, file that in a sealed cover before your lordships, my lord. If your lordships ultimately uphold this order, let it be disclosed. Until then, your lordships may keep it, my lord. Let them disclose all the assets and place it in a sealed cover before the court.
See, with regard to first direction, you can't have any objections.
But it's not, I do have some objection, but of course that has to be subject matter of the final hearing because there is an ex parte order that was operating. But I don't want to say this. I don't want to say it. It's only 2. Let them not take any precipitative steps. That's all.
No,
Can they take? That's all right.
let them, my lord, file it in an affidavit before the court. Your lordships may retain it, my lord, and hand it over to us after the hearing is over.
No need for all the sealed.
No, why not?
26 will.
Comply with the order then. To disclose, my lord, they cannot have an objection. That's why I'm
My
saying,
lord,
let
there
them
is
put
a
the
saying,
seal cover
Appana
before
beko,
your
ammana
lordships,
beko,
my
my
lord.
lord. Both father is
File
needed.
it in a
Father-
seal cover before your lordships.
Sir, it's a question of interpretation of contract, whether it has to be treated as equity
correct,
shares or as a debt, that's all.
And secondly, my lord, arbitration proceedings have started in the sense we have already made a request to the London Court of International Arbitration to start the arbitration process. Now, my lord, from the other side, there is only every method to try and prevent it.
My
As a
lord,
matter of fact, last
we,
time, Lord,
we
they
are,
said-
my lord,
sorry.
they said we will appoint an arbitrator. We said, yes, go ahead. Now, my lord, they go to London. In fact, my lord,
That's the
the term states it is LCA, my lord, London Court of International, International Arbitration, India. That has ceased to exist. That was a company. My lord, London is another company. That company says, now I will hold over. And my lord, English law will apply. All, my lord, contrary to the terms of the agreement. I'll point out all that.
Indian law
This
applies
is-
to the contract.
Yes, but English law applies to, my lord, the.
No.
The LCA, my lord,
LCIA are only rules. ICC also rules, my lord. If Indian law applies, then Indian rules apply. It is not
LCA
like
rules,
English
my
law.
lord,
English law will
specify.
apply.
English law will apply. I'll point out if it is needed.
Now, my lord,
As far as direction number 2 is concerned, why do you insist at this stage?
That's all, my lord. The
all I'm
26 your lordship
therefore
said, my
only
lord,
saying
yes,
is,
yes,
I'm not going to do anything, my lord, but I'm only saying
Leave
this.
it. My lord, if
One-
my
one
learned
second,
friend
sir.
says so, my lord, I.
No, no,
I don't want to say
one
anything
second,
more.
sir. I've not completed my full sentence.
Sorry.
I've only said half. I won't do anything, subject to you filing it before the court
Mr. Hola is younger than you.
in every possible way, my lord. He walks faster, he speaks faster, my lord, and louder.
But I'm ashamed to say he's also younger than us, even on the cricket field, I can say.
Yes.
Lord, all I'm saying is, let them file, my lord, an affidavit before your lordships. Keep it in a sealed cover. If ultimately, my lord, I succeed, let it be released to me. That's all I'm saying.
That will consider once we hear the matter.
All
Please.
Great.
So 24th, 2:30.
26.
24th or 26th?
Sorry,
26, my lord,
26.
2:30. Great.
Yes.
Good.
Great.
To give.
This for me.
Hearing for the appellants, my lord.
14. Yes, respondent number 3, my lord.
Delay, everybody appears?
Respondent number 3, my lord.
All are appearing?
1 and 2, my lords.
Yes, ma'am.
Who are the parties? Appeal is, delay is already gone down.
The delay of 37 days, my lord.
Respondent number 3 is concerned. Prepare the objection statement kindly.
My lords, please to pass an interim order on 19th of
Correct,
August.
that is what we are.
Yes.
But then this was to be heard with some other matters.
My lord. Yes, my lord. There are other matters as well listed.
Then all are already, isn't it? This is also directed to place before different bench, possible. No.
No, my lord.
See, only this another court, some other matter is there, my lord. Today listed, my
There
lord.
are other
There
like
are-
matters, but there is
That before court number 3, court roll number 3, possibly. At that time when it was clubbed to, subject to my memory.
this was the only order made, and thereafter the matter.
Were there any other connected matter, similar matter?
It is there listed
Today
today
matter,
at serial
today listed, my
number
lord. Serial number
83 to 88, my lord.
87, 88, 89, my lord.
In the list, in today's list at serial number 83 to 88, is one set of matter. There is one other matter at 89, and
Today, it can be, this can wait.
yes, my lord, this can wait. Only
My lord.
thing is, my lords had directed us to make certain deposit in terms of para number 9.2
9.2.
of the interim order, my lords. After the completion of the admission process in respect of that particular category to which admission had been made, we have made the deposit of the amounts before the registry of this honorable court, my lords. The
Differential amount
yes, my lord.
is collected, you deposited.
Yes, my lords. Memo.
When the present appeal comes up for consideration, learned advocate Mr. So-and-so for the appellant college stated that as observed to the observations and directions of the court in paragraph 9.2 of order dated 19/8/24, the differential amount of fees collected from the students admitted in the management in public NRA quota to 5 seats in question have been deposited by the appellant before the registry of this court.
Yes, my lord. My lords, similar directions operate in the other serial number 83 to 88 as well.
So 83 to 88, same order. Just check the.
And the costs have been paid, my lord.
It was stated that the cost is also paid.
We will
Send over to, it will go to now after summer holidays.
Yes.
No urgency, 18th of June.
Great.
All other give numbers to same order.
I will pass on the details to the court master.
Number 15.
State's appeal, my lords.
State
Appear for the respondent, 260 days, my lords.
Notice,
I have no, notice already have taken minutes.
notice already.
Yes, I have no objection to condone the delay, my lords. On merits, my lords,
So IA number 1 of 24, third learned additional government advocate, Mr.
Naveen Chandrasekhar, my lords. Naveen Chandrasekhar, my lords.
Naveen Chandra
Shekhar, my lords.
Shekhar for the applicant state and learned senior.
That's on merits, my lords. These workers are, daily wage workers are waiting for almost 13 years
Respondents
to
also.
get the welfare fund, my lords.
The present, we'll deal with the delay. The present application is filed seeking to condone the delay of, where is the delay?
It's 205, my lords.
Seeking to condone delay of 268. 268 days,
260, my lords.
260 days. Full stop. In the accompanying affidavit, the passage of time paragraph is explained by the applicant state. In the passage of time, it was stated in the accompanying affidavit that after the deliverance of the judgment and order by learned single judge on 8/9/23, comma. Learned government advocate gave opinion for referring the appeal thereagainst. In turn, full stop, it was stated, comma, the department concerned requested the government advocate to apply for certified copy, which was applied, and after securing the certified copy, the matter was processed in the hierarchy of the government departments, ultimately to decide to arrive at a decision to defer the appeal. Full stop. The delay of 6 days, which has taken place in process, is for the reasons administrative. Full stop. The applicant is a state. The decision-making process invariably consumes some time. Viewed from this angle, paragraph, it could be said that sufficient cause is made out. Delay of 260 days is condoned, application is allowed. So, what about appeal?
My lord,
Today or any other day?
there are 3 rounds of earlier litigation. I would like to make a note and give the same, my lords.
Let's just,
Not accommodate.
before that, 1 second, my lords. Just I will read 2 paras, my lords. That will conclude the matter, my lords. My lords, at para 7 of the learned single judge, page 24, my lords.
Yes.
A perusal of the award passed by the Industrial Tribunal would reveal that the members of the union workmen are to be reinstated, and a direction was also issued to the government to give work to the workmen to whom the work was denied, and also directed to stop contract system and maintain seniority list, and also provide medical benefits. Suffice, it is note that the Industrial Tribunal, while passing the award, took note of the fact that the workmen had already put in service for more than 8 to 9 years as on 1990. The 2 writ petitions, 2 writ appeals, and the special petitions by the government are dismissed. The fact that the workmen were employed as daily wage employees during the period from 1980-81 onwards is not in dispute. It is also not in dispute that as of the date of coming into the effect of the 2012 Act, on 15/2/2013, the workmen were already reinstated. Hence, the contention of the government that they have not put in 10 years of service as of 10/4/2006 is untenable. The reason is apparent. The workmen joined the service way back in 1980-81. It is also not in dispute that the court and the Apex Court have confirmed the said order. The reason assigned in the endorsement that the workmen joined as a daily wagers on 31/8/1998 is incorrect, since the officer concerned has misdirected himself and has taken note of the date of the award as of the date of joining as daily wagers, and erroneously concluded that the workmen have not completed 10 years of service as on 10/4/2006. On the contrary, the entire material on record would reveal that the workmen daily wagers joined the service of the respondent during the 1980-81 itself, and the award is dated 31/8/1990, and granting the relief of reinstatement, etc., clearly goes to show that they were continued to be in service from 1999 till the date of reinstatement, 2012. Hence, the reason assigned in the endorsement exceptionally illegal and contrary to the award passed by the Industrial Tribunal. For the reasons stated above, the endorsement is liable to be quashed, and accordingly it is quashed. The writ of certiorari is ordered and endorsement is also forth responding so and so. Annexure Q is quashed as directed so and so. This benefit was denied to the workers only on the ground, my lords. As of 2006, they have not completed 10 years of service, my lords. These workers are joined 1980-81. They were refused employment during 1989. In 1990, there was a reference to the Industrial Tribunal, my lords. Industrial Tribunal passed the order
to stop contract system and continue these workers in the employment and maintain seniority of these workers. Thereafter, that was taken in writ appeal, writ petition, writ petitions were dismissed. Writ appeal filed, that also dismissed. They went to the apex court also. The matter was concluded. Thereafter, they were reinstated in 2012, and thereafter, we filed another writ petition seeking the wages from the date of award till the date of actual reinstatement that was also ordered. Thereafter, by negotiations, as directed by this honorable court, matter was settled. They said that there was already a settlement, hence they are not entitled for these benefits, This Welfare Act was only to the benefit of daily wagers, who are working in the government departments. As per the notification, at page 127 is the Act, Welfare Act. At page 127, if they brought under these Act, they will get certain benefits, At page 128, from just I will read one parameters with permission.
But he wants time.
There were earlier 3 rounds of litigation, my lords. One more thing, the settlement what's been entered between the government and the workman, that's not part of the record. I have to place.
No, we have brought it record. That is on record, That is.
I'll just place a note and be prepared next week, my lords. Any date next week.
20th.
Very much.
This is number 16.
Please. While the appellant was working as a divisional manager in Canara Bank, in Pune, Deccan Gymkhana branch, Pune, a letter of credit was issued in favor of an important customer to the Bank of India branch. Somehow after post-retirement, finding fault with it, a disciplinary action was initiated. CBI investigation was also done. And now, the pension has been withdrawn, which has been, upheld by the Honorable Single Judge. Today, my friend colleague has fed me with some more decisions in this similar banking transactions. If my lords are pleased to grant me 2 days' time, I'll go through those judgments also and the Bombay High Court also, the criminal appeal is, coming up for hearing.
Go to 23rd April.
Please,
23rd April.
No, early, because Monday also I can get ready.
Monday not.
Yes, what
Actually,
is,
today or
because the entire pension is withdrawn and one.
prepare yourself.
I am ready, I'm only one reading those judgments. Tomorrow or Monday I can.
Then tomorrow, Monday not possible.
Any earlier date if we can.
23rd.
23rd of please.
17 is urgent. Still number 18. MC Busuraj.
Delay.
300 days.
What are the reasons?
But, the appellant was a driver. She dismissed the employee, my lord.
But where is your delay confidence?
And notice is not at order.
Where is the delay?
The appellant is a dismissed employee.
This doesn't explain delay. The present application filed, present affidavit filed in support of the prayer for condoning delay of 300 days does not make out a sufficient cause. However, it be open for the petitioner to file a supplementary affidavit and to establish the sufficient cause for delay to the extent of 300 days. Next, stand over to 10th of June. This is nothing you have stated except that you have financial difficulties.
Yes, I will.
300 days, there is no such.
Please.
Yes.
This is number 19. Mr. Prashant.
I appear for respondent 2 and 3, my lords.
Lord, in
Here for the
serial number
appellant.
19, my lord, the process is completed. There is a connected appeal, my lord, that's listed today before your lordship, serial number 68. My lord, there also, there is, it appears that R4, perhaps the Central Government Council could take notice, my lord, that will complete the process there.
Take notice for it.
In serial number 68,
Yes, ma'am.
I'm grateful, my lord, to my learned friend. My lord, there is another appeal that's not listed before your lordships today, my lord. Your lordships permit me if I can make this submission. Your lordships keep this matter in the first week of April. The other matter, I'll have it brought up, my lord, in the next week. Get notice ordered. They're all only government parties. I'll get that served and tagged along, my lord, on the date that your lordships keep it for hearing. Your lordships permit, because your lordships have already indicated matter has to be heard finally.
My lord, one slight inconvenience. Senior counsel is on his legs. If your lordships may kindly pass over also, senior counsel.
He is asking for first.
There is one more appeal that's not listed, my lord. Let all three come up together, my lord. We'll come, because instead of the third appeal is not yet, the notice is not ordered on that, my lord. That's why I'll just have all three tagged together and.
This writ appeal 1703. This appeal shall be listed with the cognate appeal number 68, 068 on 4th of April.
4th April. So great.
Please.
Lord, and in 68, my learned friend will ensure copies are served.
Learned advocate
Great.
so accepts copy on behalf of his for in writ appeal number, whatever number is then 68. What's your name?
Reshma Tamayon.
Yes.
Grateful. Very good. Seal number 20. The Shupashri.
The question of law raised in this appeal is whether a workman could be given interim leave only on the ground that he is not employed, or is it required of the court to look into the prima facie aspect of the case also? There could be a serious act of misconduct by a workman, so much so that no court would give him relief. And yet, because he is not employed, I give interim leave, means you are fixing premium on his misconduct. Here is a case where a workman deliberately slows down production to such an extent, it does not come even to 10% of the normal production given by the other workman. Charge sheet is issued, inquiry is held. Inquiry is set aside only on one ground, that the outsider whom he demanded should represent him was not allowed in the inquiry, he walks away. Therefore, it's an ex parte inquiry, and therefore inquiry has been set aside. That apart. The question is, neither the labor court nor the learned single judge even go into the question of what the misconduct is. Is that permissible is the question. There are judgments which I have produced also to show that even the courts have taken a view that you should not merely on the ground of unemployment, but there should be some evidence with regard to the merits of the case and then deal with merits of the case. Therefore, my submission is to grant interim leave only on the ground that the workman is not employed. In this case, of course, his wife was a nurse in a government hospital. He also had few acres of land, but the learned judge says it is somewhere in an area where there may not be rain at all, and therefore he may not get any income. All that is apart. I am only on the question whether that is the only ground on which the court should consider an interim leave application, or should the court consider the prima facie aspect of the matter also. That is the question raised. Now, I've produced the judgments of this honorable court, where identical issue has been gone into and settled.
The workman is reinstated?
No, Lord, not reinstated. Domestic inquiry is held to be not fair and proper. So then, my lord, I made an application that I continue to be in employment. So give me 50% back wages, so I have to survive. That interim order is under question in this writ petition. Main matter is still pending. So the courts have taken the view, when domestic inquiry is held to be not fair and proper, that finding is accepted by the management also. I continue to be an employee, I'm entitled to seek for an interim relief. That has been confirmed by the court, my lord, in a company like this.
So you are in employment?
But I am an employee.
No, you are not reinstated.
No, I am not reinstated. I have to leave.
And that has been stayed, my
And
lord. That order be stayed.
This is not 17B order.
no, not 17B, but on the principle analogous to 17B, courts have taken the view that where the domestic inquiry is held to be not fair and proper, I continue to an employee. Similar to 17B, I am entitled to seek for interim relief. In a company like Toyota, my lord, it is surprising that on an interim order without paying me anything, till date they were not complied with, not a single paisa is paid. I am on the streets. And now, my lord, an appeal is filed on an interim order.
But my submission is merely because inquiry is set aside, you cannot say he is in service because that order is also stayed by this court. Now, my lord, why the inquiry was set aside? The workman said, I want an outsider who is a union leader. The standing orders did not provide for it. The inquiry officer said, I can't allow you to have that outsider. He walked away. Now, if every workman walks away from the inquiry saying, please allow me to bring whomsoever I want, which is not a part of the provisions of the service rules or regulation, standing orders, where should the employer go? Therefore, there are certain limitations on who can represent a workman in an inquiry. Obviously, the courts have taken the view. In fact, judge of the Supreme Court says, if there is a clause that no outsider should be allowed, you need not allow him. In fact, even advocates are not allowed unless the presenting officer is a person who is well literate in law. No, my submission is only this. In every case, if the court were to take a view that setting aside of an inquiry will result in grant of interim relief. So for some reason or the other, the workman can ensure that the inquiry is set aside either by not participating or by saying, I am not given sufficient opportunity in spite of 20, 30 opportunities being given. And then say, give me interim relief because inquiry is set aside. In fact, in Firestone case, Supreme Court said long back that I can even dismiss without holding inquiry.
Any judgments in your favor?
Well, may I point out a judgment? Though I have produced several, I'll only refer to one or two judgments. The other judgments are on maintainability of the writ petition, which I will not go into because you want to understand it is referred to a larger way.
What is referred to?
But that is on a labor court award. Courts have taken the writ petition is not maintainable. I was given to understand that another court has referred that judgment to larger bench. I am not aware, but the courts have taken the view that writ appeal itself is not maintainable. That your lordship last time referred to that Tamanna's case. That is followed in the index plot I have given. Serial number 5 is Tamanna's case, followed in 1 to 4, all of the judgments have followed with regard to maintainability. But with regard to this payment plot, kindly go to page 213. This on the merits of the matter. The division bench judgment. Lord, at page 221, I will copy it. At page 221, after referring to several judgments, if that be the power of the tribunal, then what would be the status of a workman who has been dismissed? Your lordship got it. Page 221. If that be the power of the tribunal, then what would be the status of a workman who has been dismissed and the domestic inquiry conducted with the management proceeding, the dismissal has been found fair and proper? By virtue of section 11 of that, the tribunal has still to pronounce on the propriety of the quantum of the punishment imposed. As noticed by this court in Mysore Cement's case referred to Supra, A dismissed employee pending adjudication on the question of validity of his dismissal occupies the status of an employee suspended pending inquiry. If that be so, interim relief that is being awarded will partake the character of wages being paid to subsist during inquiry. An employee suspended pending inquiry is entitled to receive subsistence allowance as well. Then, my lord, next page at 223. At page 223, we find that this is what was stated by the Supreme Court briefly earlier. Where you are reading? In page 223.
226.
223.
220. Yes.
There on the top, my lord, we find that this is what was stated by the Supreme Court briefly earlier in Fakirbai Pulabai Solanki versus presiding officer and other, because it is difficult to anticipate the results of an application made before the tribunal. It is reasonable to hold that the workman against whom the application is made should be paid some amount by way of subsistence allowance to enable him to maintain himself and the members of his family, and also to meet the expenses of the litigation before the tribunal. And if no amount is paid during pendency of such an application, it has to be held that the workman concerned has been denied a reasonable opportunity to defend himself in the proceedings before the tribunal. Such denial leads to violation of principles of natural justice, consequently vitiates the proceedings before the tribunal under subsection 3 of section 33 of the Act. Any decision given in these proceedings against the workman concerned, hence the tribunal or the labor court, is yet to pronounce on the propriety of the punishment imposed on the worker. The worker is equated to the status of employee suspended pending inquiry. If so, it's contemplated under service jurisprudence. In such a situation, to contend that the finding of the domestic inquiry by the Tribunal Labor Court is a sine qua non for considering as to whether interim relief has to be granted or not is a correct proposition of law. The final outcome of the adjudication of the dispute referred to a tribunal as regard dismissal of an employee is not solely dependent on the question whether domestic inquiry has been held and held validly. It depends on sufficiency of other circumstances such as fair play, fair inquiry, proportionality of punishment, perversity of finding, etc. Hence, interim relief is being granted to the worker for the purpose of maintaining him during the tribunal adjudicates the dispute till the court finally adjudicates on the issue. Though in other services, final order of punishment would have visited the employee facing an inquiry. Absence of that circumstance alone cannot make any difference. Due to the intervention of Section 11A of ID Act, punishment imposed on the employee would take effect only after the same has been upheld by the tribunal. Though no doubt from the earlier date of imposition of punishment, see so and so. In these circumstances, we are of the view that the award of interim relief in an industrial adjudication is not dependent on the finding on the issue on validity or otherwise of the domestic inquiry. It is to be awarded notwithstanding the finding with reference to validity of domestic inquiry. Therefore, there is no necessity for the labor court to defer consideration of the application for grant of interim relief till it enters a finding on domestic inquiry. If so, the learned judge was correct in dismissing. We do not find any grounds. Then, my lord, there is one more judgment at page 258.
238.
258 is the relevant portion. It starts from page 225. Only one para I'll refer to. Page 225. At page 259, para 38.5. The cases in which, page 258, para 38.5. The cases in which the competent court or tribunal finds that the employer has acted in gross violation of statutory provision or the principles of natural justice, or is guilty of victimizing the employer or workman, then the court or tribunal concerned will be fully justified in directing payment of full back wages. In such cases, superior courts should not exercise power under Article 226 or 136 of the Constitution and interfere with the award passed with the labor court merely because there is a possibility of forming a different opinion on the entitlement of employee workman to get full back wages or the employer's obligation to pay the same. Court must always keep in view that in cases of wrongful illegal termination of service, the wrongdoer is the employer, sufferer is the employee workman. There is no justification to give a premium to the employer of his wrongdoings by relieving him of the burden to pay the employee. Workman is dues in the form of full back wages. Here, my lord, only half 50% of the back wages is paid. Similar view is taken, my lord, at the division bench of this honorable court at page. One of the point they argued before the learned single judge at page 274 that you have 2 acres of land, therefore you should not be paid. Page 274. In Haveri, you have 2 acres of land in the joint family, therefore we will not pay you. 274. The judgment starts at para 13 at page 285. Para 13 at page 285.
So that is self-help payment for earning is not employed.
Yeah, that is not required. In fact, that is the main difference before the learned senior. You have 2 acres of land, so therefore we will not pay you. That also has been negated. They say that if you go and beg, that also to be considered as self-employment. That has followed in several cases. I don't want to multiply it.
What my learned friend read was, when the tribunal has come to a conclusion that workman is not guilty. Kindly see what he read at page 224. What it says is, at para 9, it says you cannot go by, you have to wait for the outcome, and then if there is a sufficiency of other circumstances such as fair play, fair inquiry, proportionality of punishment, perversity of finding, etc., etc. No such finding is given in this case at any point of time. And then the other one was at page 357, which my learned friend read. Kindly see, my lord, what were the facts of that case at 357? 57. Back page 274. Page any This, my lords, which my learned friend read, was pertaining to a matter arising under section 17, capital B, with regard to wages to be paid during the pendency of a dispute before the labor court, where the workman has already been reinstated. It's already been reinstated. The question is, 17B, can it be denied? Obviously, the courts have said, once there is an order of reinstatement, you are bound to pay the wages during the pendency of the matter before the High Court or the Supreme Court. So I don't think any of these cases said that even in such grave cases of misconduct, you must give interim relief. My submission is, in fact, I have produced, kindly see, my lord, the order passed by this honorable court at page 21 of my paper book with regard to the cases, where it clearly they refer, in the case of Sampath BG versus State of West Bengal and others, a full bench of the High Court of Calcutta has observed as under. There cannot therefore be any doubt that once an interim relief is prayed for, the tribunal has to apply its mind as regards the existence of prima facie case. What would be the nature of prima facie case in such a situation is one of questions which also arises for our consideration. Then I don't want to read the whole thing and trouble your lordship. I'll go to paragraph 12 at page 23. However, a bare perusal of the impugned order clearly reveals that although the learned tribunal had framed issue number to see whether a prima facie exists or not in favor of the workman, but the said issue has not been decided by the learned tribunal. The learned tribunal has merely taken the ambit and scope of the act as a guideline and has granted the interim relief in favor of the respondent. Therefore, the learned tribunal has missed the wood for the trees. Since the learned tribunal has failed to exercise the minimum that is required of the learned tribunal, this court has no other option but to set aside the impugned order dated so and so and to remand the case to the tribunal. Now kindly see, my lord, this is a judgment of this court. And I produced one more judgment of this court, which also says the same thing, that you cannot just kindly see, my lord, at page 35, page 35 of my case paper book, where this court once again considered that issue. Then
Where is it?
they refer to once again full bench of the Calcutta High Court at paragraph 9. And thereafter,
Where is it? Paper?
finally, what the court says.
Given by the others.
36.
So what you are showing?
List of authorities, my lord, which are.
Where we are? At which page?
Page number 35, 36.
Page number 37 may kindly be seen, my lord.
Yes.
Page 37, about 10 lines from the top. As stated earlier, it starts, my lord, about 10 lines from the top. As stated earlier, the only ground given in the petition was that respondent number 2 was unemployed and was undergoing great hardships. That merely cannot be a ground for grant of interim relief of the kind granted by the tribunal. It was incumbent upon it to discuss some facts of the case and to find out prima facie in what way the order of termination of service of the petitioner seemed to be unjustified. After recording such a finding, the interim relief could be granted and not otherwise. The interim order or award of the tribunal therefore suffers from an infirmity of the kind which would justify its quashing by grant of a writ of certiorari. That is by this court, my lord. And there's another judgment also of this court on the same matter. Page 35. There's one more, my lord, your lordship gets at page 23 of this honorable court again. This is what I read, my lord, at page 23, paragraph 12. And then what I read to your lordships. Both are the orders passed by this honorable court. And there is also another. I produced the full bench order of the state of West Bengal also, a portion of which I read to your lordship because it was extracted by our court in its judgment. Then your lordship may have a look at. I think that suffice for me, my lords. Two orders which I have read to your lordships are the one which are holding the feet.
So to be treated as final hearing?
Only one point.
Will final disposal.
Very well, final disposal. This domestic inquiry is held to be not fair and proper. That finding is there, that page.
That we have seen. Yes.
That is that page.
There's no dispute about it, madam.
No, but
The court has held that domestic inquiry is not fair.
at page 67, relevant page is at page 80, 81. Thereafter, the interim relief is considered. There is no need to once again discuss the same thing.
So. Or learned. Senior advocate, Mr. You are Mr. Rupasari.
Rupashi is the advocate on
learned
record, my lord,
Rupasari.
myself, S.N. Murthy.
For the appellant and learned senior advocate, Mr. Ashok Haranhalli, assisted by learned so at length, learned counsel for the party stated that they argued the appeal. Finally, they further stated that the proceedings are over and no further are required to be added or supplemented. Full stop, reserved for judgment.
Right.
21, 22 are agendas. Number 23. Nidhishri PV.
Appearing for the petitioner, there is a bereavement in the arguing counsel's family may be taken after 3 weeks.
The request on behalf of learned advocate for the appellate petitioner.
May I request, my lords, I am for the respondent. I'll have to file one statement, my lords. Another 3 weeks, my lords, I'll try to get the instruction. I'm on
From
NOC brief.
The arguing counsel has personal difficulty from a stand over to.
May the interim order may be extended, my lord.
Interim order is there,
Yes, my lord.
9th of June. Interim order granted earlier shall continue to operate till the next. In the meantime, the reply affidavit, if any, shall be filed by the.
Brief.
24 is agendas. Number 25. Vishwanath. 25.
Seeking strict implementation of the ward committees under section 80M of the Karnataka Municipalities Act. My lord, it is a mandatory provision of law, section 80M. It states that it shall be implemented. Then also, my lord, even till this day, we are not able to see any kind of ward committees running in our council. My lord, it has been four adjournment dates, my lord.
Reply shall be filed with the next date.
My lord, already a year has gone by.
No, I won't move for any further adjournments. my lord.
Stand out to 11th June.
Obliged.
Number 26. Chekki Siddhavi.
Lords, in this writ petition, I am seeking a writ of mandamus to the respondent to consider my representation, my lord, which is at annexure F1 and F2 at page 58. The translated copy is at 61. I made a representation to the respondent subsequent to an order passed by this honorable court, my lords, which is at annexure B, my lords, at page 27. It has been ordered to consider my representation within 8 weeks thereafter, after giving opportunity to the all the parties concerned. Subsequently, I made representation at the annexure D1 and D2.
What happened to earlier representation?
They are not considered, my lord.
What is the decision?
My lords, that is at
So every time you can't file
annexure C.
petition for every repeated representation. Where is that page?
Annexure C, my lord, at page 30.
13.
30.
30.
The translated copy at annexure at page 31. This is the representation which I have filed subsequent to immediately after the disposal of the earlier petition. And thereafter, series of representation has been made, my lord, at annexure D1 and D2. In the meantime, my lords, at annexure E, on 7 March 2023, respond number 4 has passed an administrative approval for granted the amount.
Where is the decision on your earlier representation?
They have not taken any decision.
My lord, then I'll verify and I'll make my submission. Why this is not done. My lord may have this next week.
There is nothing. Every time you can't go on filing. Find out what is happening.
Yes, yes.
26th of February, March.
Obliged.
Obliged. So 27, 28 are agendas. Number 29. Ramesh Naik, M14.
Matter is about constitution of biodiversity management committee at every local body's meeting.
For the respondent number 3 in this matter, my lords, I'm yet to receive instructions. As regards the objections, I'll be requiring 2 weeks time to file my objections.
Mr. appears to take time.
This is an important committee, my lord.
Reply time is granted, stand over to June. 18, before which date the reply, if any, shall be.
My lord,
Much obliged.
December 30. Ravindra Gajanan Kodle,
June 18,
June 9,
18.
June 8, much obliged.
Karnataka government advocate list, because interim orders have been granted, my lord.
What interim?
So that,
Granted.
yes, they subsequently filed applications and an order is passed on 17/12/2024, my lords.
What happened? What
Last
is
by
midtime?
I apologize, my lord.
Third
the
April.
interim order may kindly be
It
continued.
is not limited. Let us see.
My lord, status quo was granted on 17/12/2024.
Not limited. 10 or 2.
Please,
First April at the request of learned additional government advocate.
My lord, second or third, if it is possible.
3rd April. At the request of learned additional government advocate, Nilofar, who wants further time to take instructions.
please, my lord.
December 31. Mahendra.
My lord, in this, considering that there is an, my
yes.
lord, amendment dated 30/12/2024. My lord, I'd just like to seek seek instructions, my lord. My lord may have this next week.
So then it will go after. No? Any urgency? Then
There's no urgency.
This is a very simple matter, wherein, Lord,
16th April.
Lord, Annexure A may make one submission. Annexure A is the proceedings of the District Task Force Committee, which sought for no objection afresh. Now, by the virtue of the amendment on 30/12/1994, the district's role of District Force Committee has been omitted.
Roll up
District Force Committee has been omitted.
that you are arguing in that.
Yes,
My lord, it is in respect.
that is all
of
the
that
matter, Lord.
To seek written instructions and make my submissions.
15th April.
My lord, 16th is all right, my lord.
Not far.
December 32. 32.
My lord, 32 also, I need some time. my lord.
15th.
Lord, this is the 4th time, Lord, because my query is suspended.
It's not the.
Lord, my submission is, Lord, the geologist, he has no authority to seize the quarry unit at
My
all.
lord, please see the grounds, my lord, that have been raised. He admits the
Normally,
crusher unit which
No,
is.
let
supposed
them
to be
file
done-
objections. It's simply loose submissions are made before the court without filing objections.
Tell me from making submissions.
normally government advocates is quick and fast in taking instructions, but he is infected the slowness of the court. We are slow. Right? So let her take instruction.
That's a crusher unit.
Without her instruction, we can't be.
I understand, Lord. The thing is, crusher is stopped. There are 50 workers.
My lord,
But,
officers, my lord.
All
they
that we are
given a-
requesting is, Lord, since there is a new survey conducted.
8th April. 8th April.
Number 33 is attended. Number 34. Mati Maitreyi Krishnan.
In this matter, this is,
Appearing for the petitioner in this matter.
this matter pertains to manual scavenging.
Intervener.
Manual scavenging matters, my lords. My lord, on the last date, we had submitted a report. The petitioners were supposed to look into it and reply. Matter requires a hearing.
Just one submission, there is also a matter going on in the Honorable Supreme Court on the implementation of this law. And in fact, last month, the Supreme Court passed an order saying that in the 6 metropolitan cities of India, which includes Bangalore, Mumbai, Hyderabad, Delhi, Chennai, and Calcutta, immediately all manual scavenging and manual sewer cleaning will be stopped, and commissioners of those cities to give a affidavit to say what they have taken. In fact, out of the 6 cities, 5 city commissioners have given that affidavit. Bangalore BBMP has not even given that affidavit to the Supreme Court. It shows that when the Supreme Court has directed that in Bangalore, as one of the cities, there will be complete ban, even the BBMP has not filed a affidavit, my lords.
But then the proceedings before the.
Apex court.
No, that is before
My
the
lord, the
apex court.
proceedings before the Supreme Honorable.
Some bearing on this.
The bearing only is because this shows.
Yes, my
what is
lord.
the implementation.
This
is.
matter, my lord, may please see my petition. There are 9 kinds of manual scavenging that are happening in the state of Karnataka, my lord, not just in Bangalore. This honorable court, my lord, was pleased to issue notice as passed detailed interim orders. In fact, one of the interim orders that was passed by this honorable court is that survey has not been conducted across the state. Committees have not been constituted. So that order, my lord, has been passed by this honorable court. Thereafter, there have been a series of deaths that have happened, which compelled this petitioner, my lord, to file IA number 1 of 2024.
You are in one of the petition or petitioner.
I have impleaded in one of the petitions.
Impleaded.
I'm appearing for the petitioner, my lord, in 8928, my lord.
First 8928, yes.
Happy to pass over the.
Who will appear for BBM?
Appear for BBMP, my lord. Recently, we have filed Vakalat, my lord. A week from this.
This is a very old matter, madam. This is of 1820.
It was with Mr. Puttegoda. He is not appearing on behalf of BBMP. We recently handed over to us. I'll take instruction.
My lord, page 17 of my petition may please be seen, just to understand the scale of manual scavenging that's happening in our state, my lord. The Honorable Apex Court, my lord, in 2014, said that this is an obnoxious practice that has to be nipped in the bud. Today, my lord, 11 years later, we are still saying that this is happening. Recently, my lord, 2 more workers died in Bangalore in a plant while they were cleaning a sewage treatment plant, my lord. At page 17, my lord, we've just given an index, my lord, just because of the voluminous of the petition. There are 9 types of manual scavenging that are happening in the state of Karnataka, my lord. One is its most primitive form, which is how it was understood under the 93 Act, where you have dry toilets and you have to go clean it. Secondly, my lord, septic tanks and soap pits. Almost 60%, my lord, of the cities in Karnataka, urban local bodies, do not have drainage. So they have soak pits or they empty it directly into the drains. That is again being cleared manually, my lord. Thirdly is the sewerage systems like the BWSSB in Bangalore. Fourthly, my lord, even solid waste management. Because of open defecation in several cities, the sweepers in the cities, my lord, they are forced to clean manually. Then we have STPs, my lord, then toilets and railways and defense establishments. My lord, in fact, there's a committee report of our state government in 2014 which identifies all of this and says action should be taken. Because no action was taken, my lord, we came before this honorable court. This honorable court, my lord, first considered whether the enumeration of manual scavengers has happened at all. And having seen that that was not done, a detailed order came to be passed by this honorable court, my lord. Thereafter, my lord, the matter is now ripe for hearing, is my humble submission, my lord.
State has filed reply.
We have filed memo of compliances. Various memos have been filed, my lords.
My lord, objections will have to be filed to the issue, my lord, if a comprehensive kind of resolution can be arrived at, my lord.
Directions of the Honorable Supreme Court because it pertains also to Bangalore. In fact, it shows the seriousness of the matter. If I could.
And this is the second round, my lord. In 2009, there was another matter that was filed before this honorable court.
CE state government.
Please, my lords.
It requires a lot of education to the masses also. See, under this one, what is it? The toilet drive that the central government initiated.
Swachh Bharat mission.
Swachh Bharat thing. So many toilets were constructed in, especially in Hyderabad, Karnataka area. They made it into godowns. This is a fact. They made it into another room and people are again defecating outside.
point. Thereafter, they say that there are no insanitary latrines and there are no manual scavengers. That is what the government is
No, they
saying.
took the subsidy. They took the subsidy. Rooms have been constructed. Toilets have been constructed, which are being used as rooms. No, they are functional. See, it also requires
The local
mass
bodies.
education to the people. And another related menace is in so many areas. The same pond is used for all purposes, for drinking water, as a toilet, and for washing clothes and washing cattle.
And also, my lord, toilets without water supply and drainage will, as my lord said, it will become just another room for all practical purposes.
No, it requires people participation also. You need to have certain programs for that also.
Importantly,
Lord,
the
as per the 2020.
cleaning, where people are dying because of the manual sewer cleaning, that
Correct.
there are deaths. And if I can just pass on that judgment, order dated 29/1, my lords, of 2025. If my lords just sees on the second page, second last, just the second page, second last para. The court directed, we hereby intend to stop manual scavenging and manual sewer cleaning in all the top metropolitan cities of the country, Delhi, Mumbai, Calcutta, Chennai, Bangalore, and Hyderabad. We have been informed at the bar that in all these metropolitan cities, which we have indicated, all modern scientific machinery and tools are available for scavenging and sewer cleaning without active human participation. Therefore, manual scavenging and manual sewer cleaning should not be required. We therefore direct that the chief executive officers, by whatever name he or she is called in the state, of each of the above mentioned metropolitan cities to file precise affidavits before this court apprising as to how and when manual scavenging and manual sewer cleaning was stopped. I mean, this is only to say, of course, they have to submit it there. But my lords, it is quite sad if Bangalore is the only affidavit which is not filed.
May make one submission. My lord, I appear in writ petition 676, that is by the Sumut Registrar General, which, if your lordship may kindly turn to my compliance affidavit, which has been filed, sir. I just. Six, seven, six.
676.
Filed on 30th January 2024. 30th Jan. As page 4 of my affidavit, my lord. Your lordship was pleased to post the with regard to the awareness, my lord. If your lordship may kindly come to page 4, para 9, my lord. Lord, the government had launched, may I read it out? The government had launched the mobile app Swachh Bharat Abhiyan in the year 2014, 24/12/2020 to enable the public to upload the details of insanitary latrines still existing with the geotagged photographs and the manual scavengers associated with such latrines. The application is available on Google Play Store for free download. Out of 6,253 data uploaded on the mobile app, not a single sanitary latrines have been confirmed. As on 31/12/2020, 12/2023. My lord, this is with the data given by the other states. Out of 766 districts in the country, 729 districts, including all districts of Karnataka, have been declared themselves as manual scavenging free. Out of 17 crore toilets have been constructed in the country under the Swachh Bharat mission, and identify manual scavengers have been rehabilitated. The rehabilitation benefit include one-time cash assistance, skill development, training with stipend, scholarship of the children who are engaged in unclean occupation, concessional loans with the subsidy for taking alternative employment. The Ministry of Social Justice and Empowerment has provided with the following benefits for manual scavengers under the Central Sector Scheme, Self-Employment Scheme for Rehabilitation of the Scavengers. My lord, now, my lord, the second para, my lord, your lordship was pleased to ask with regard to the awareness, my lord, in addition to the above, following has been achieved. Out of 1,563 workshops have been organized in various ULBs since 2017 and 18 for spreading awareness about the prevention of hazardous cleaning and sewer and septic tanks. 275 health awareness camps have been organized in the workplaces in the manual scavenging and sanitation workers. Covered over 18,494 sanitation workers under upskill training programs. Hazardous cleaning, my lord, my lord, hazardous cleaning of the septic sewer tank is prohibited, my lord, which the act itself, my lord, we have made it as it is prohibited. So therefore, my lord, the submission is this, my lord, the act has to be fully implemented by the states also because it is the sanitary, my lord, under the state list, my lord.
We are strictly implementing the instances which is brought to my knowledge of my lords is about some private companies, my lords, which has indulged in that. We have initiated inquiry, we have closed their units and we have rehabilitated them. We have compensated to such manual.
Why BBMP is not so far appearing?
BBMP will have to file a report, but on the whole, my lords, the compliance report, if my lord says.
The present batch of public interest petitions relates to the abolition and discontinuance and abolition of the social evil of manual scavenging. The petitioner seek direction to discontinue the evilous practice throughout the state paragraph. While the counters are filed on behalf of the state and Union of India, respondent Bangalore Mahanagarpalika, which will be in charge of the city of Bengaluru to look into the issue and respond to the court about the subject matter, has so far not cared to file any reply. So, learned advocate, paragraph Miss so and so appears today to submit that she yet to file wakalatnama in place of the previous advocate who was appearing. To state further that the wakalatnama and the replies will be filed to both the next date, not beyond 27th March. Put up on 27th March.
My lord, is it possible to have it in the first week of April, my lord? In the
First
last
week
week
of
of March, I'm traveling, my lord.
7th of April.
I'm grateful, my lords.
Grateful.
Insofar as
Apologies, my lord, for that.
One more submission. Insofar as the railways is concerned, my learned friend was pleased to make submission that railways was also not following. My lord, in strict compliance of the Balram Singh case, my lord, we have followed in railways also, my lord.
So any development which takes place in the meantime before the Supreme Court, is just
Grateful.
Great.
It's number 35. To Gauri Shankar, yes, party in person.
Sir, Gauri Shankar, party in person, joining through video conference, sir. I can make my submissions on video conference, my lord. If you allow me, I will talk over video conference, or else I will come and present in person, my lord. This matter is on the HSRP, High Security Registration Plate, which has been mandated all over the country for new vehicles.
Private litigation is going on.
Yes, my lord.
Please, my lords, the writ petitions are pending before the single judge.
My lord, this is a different matter, my lord. I want to submit a different point, which is not relevant or inconsistent with the other petitions, my lord.
My lord, I'll file my objections to this, my lord.
Let the objections be filed.
Okay, my lord.
The state, before the next date, put up on somewhere in June, 28th June.
Okay, my lord.
Number 36, Rupesh B.
Therefore, the complainant
So we filed our complaints.
has
that-
not been complained.
Not complete.
For the learned signature, by lot, an endorsement for crashing of
There's an interim order passed by this honorable court, my lords.
Interim order.
Produced at annexure R2 page, page
Which is the order under contempt?
8, my lords.
Page?
annexure D, page 67, my lord.
67.
There is one for certiorari and another is for mandamus. Page, para 3 of page 69 is the order. Mary. With regard to endorsement dated 2/3/23, a writ petition has been filed and a stay has been passed. With regard to Addubas and Podi, which is the part of this contempt petition, where annexure C series is not a part of writ petition, which my government advocate is relaying. For conducting of Addubas and Podi, there is no stay, and that is separate survey number.
Yes.
Lords, unless revenue entries are to be made, my lords, your lordship may take my compliance affidavit. We have issued, this is tenancy rights, my lords. We had to issue notice to the landowner who is in possession of the land. Lordship may take page 6 of the compliance affidavit. We have issued an endorsement that we are entering the subject land in the name of the complainant. We are about to comply. My lords may take page 8. They approach to the Honorable High Court and an interim order is passed, which goes to say that Tashildar is respondent number 3 is directed not to alter the extent reflected in RTC as on today, pending consideration of caption petition.
That is in respect of.
My lords, unless revenue entries are entered, how we can conduct Podi and the rest, my lords?
That is in respect of survey number 36 2P, my lord. My application for conduct and Podi is, my lord, at annexure C series to this writ. That is survey number 9/2, survey number 53/2, survey number 55/1 is concerned. The order passed by the learned signature is with regard to another survey number.
Which
I am
one? That is,
36/2P.
that is what the your.
That is 36/2P is the subject matter of the writ petition also. Your lordship may kindly take.
One is for certiorari to quash the endorsement dated 2/3/23, and another is for mandamus, that is H series, my lord.
Then get the clarification from Lona Singh.
Please,
Annexure C series.
There is no contempt.
please.
If you have some submission in respect of the different survey number, then you need to seek clarification.
Annexure C series should be complied by.
But the operative direction doesn't make any distinction.
Please.
And your subject matter was occupancy rights, you were claiming dispute 36 2P.
Please.
And annexure H series. H series is.
Maybe, but it is not dealt with in the operative part of the order launching.
They're just not written, but.
Then not written, then there is no contempt.
Writ of certiorari and writ of mandamus. With regard to mandamus is H series is correct.
Then there is no granted regard to writ of certiorari.
The certiorari is quashed, and thereafter H series has been directed to consider.
Where is that quashed?
Here, my lord. And in page 4, para 70 of the order, I permitted to read from the first top. This court has granted occupancy rights in respect of Srimati Girija. I am of the opinion that respondent number 3 should have directed the parties to file appeal before respondent number 2 hearing. Taking into consideration of the facts, I am of the opinion that respondent 3.
Where you are reading?
Page 70 of the order. From top. This court has granted occupancy rights in respect of Srimati Girija. I am of opinion that respondent 3 should not have directed the parties to file appeal before the respondent number 2 hearing. Taking into consideration of the facts, I am of the opinion that respondent 3 has committed an error.
What is set aside?
2/3, an endorsement has been issued by the Tahsildar to approach the Assistant Commissioner to seeking to
rectify the RTC entries with regard to 36 2P is concerned. That has been set aside. A separate application has been filed by Annexure H series to conduct Cody and Duras in respect of other properties is concerned. That is H series is concerned. That is not
In that regard, there is no direction.
Annexure H, further, my lord, which required to set aside and matter reminded to respondent number 3 herein to consider the applications made by the petitioner as per Annexure H series seeking Cody and Addubus at the earliest. Having arrived at a conclusion to set aside the endorsement dated 2/3/23, respondent is directed to enter the name of legal representative of deceased Girija in the revenue records with an outer limit of 2 months from the date of receipt of certified copy of.
Then you go before learned single seek clarification. Because there is no specific direction which would be complied with in contempt. You may be right, we do not know. Unless there is an explicit direction, the contempt
I
will
have
not.
produced the Annexure H series is.
We are concerned with the operative direction of learned single judge. It doesn't mention any survey number, doesn't even give any direction with regard to the survey number which you are referring to.
I move an application.
Learned advocate. Prima facie, there is no contempt of the court since the learned additional government advocate submitted that the. Where is that?
That's page 8 of the compliance application.
That indeed petition number 3788/25, learned single judges passed interim order whereby the petitioners of the said petition have obtained interim relief in respect of survey number 36 2P.
Please.
And that the learned single judge has stayed the order dated 24/1/25 passed by responsive Tehsildar till further orders. Full stop. Learned advocate for the petitioner, however, would submit that part of the directions of learned single judge which are brought under the contempt jurisdiction relates to different survey number. Full stop. The said aspect is not brought out from the observations and directions of learned single judge while disposing of the petition. Full stop. Having noticed this above aspect, learned advocate for the petitioner wanted time to seek to take out the proceedings to seek necessary clarification before learned single judge. In view of the request, stand over to 11th June.
So 37 is urgent. Still number 38. Mr. Ravi HK.
Lord, this is a matter where BDA was directed to implement its own order of demolishing the illegal structures.
The review petition is filed, my lords, and the review petition was listed yesterday. The learned single judge has issued notice in the review petition.
Then we dispose it.
3 months' time was granted.
Review petition is pending.
It's pending, my lords. It was listed yesterday, and the learned single judge has issued notice, my lord.
It was stated that the review petition is filed in respect of the order and judgment and order brought under contempt, and that in the said review petition, learned single judge has issued notice. In this view, this contempt petition may wait to be adjourned to 10th of June.
Right.
So number 39. The Maitri Krishna.
The last date, my lord, this honorable court had directed me to plead the party, my lord, where the complainant was working. That has been done, and they have come on record as A5, my lord.
I'm for the A5, my lords. Kindly,
detailed order was passed on the last date, my lord, on
20th January.
Please.
Yes. So what are the order?
The order was, my lord, to implead the employer and for notice to be issued to them. That has been done, my lord. And the amended petition is also filed.
What?
My lords, I seek time for my reply, my lords. I'm for the A5, my lords. I seek time for my reply.
You think, then we don't think.
Kindly, my lords.
You want time or you think to
I want time, my lord.
Tell us. Stand out. When shall we?
A week's time.
Your phone number 4.
A5, my lord.
5.
File. On behalf of this one note 5. Time is prayed for to file an affidavit in reply. Stand out to 28th of March.
Simba 40, Venugopal MS.
Lord's writ appeal 1705 of 24 has
Complainant.
been preferred.
1705 of
1705 of 2024
is pending.
pending. We'll do the necessary compliance.
What is the stage?
Stage is
Yet to be
non-compliant.
complied.
stage. 3 weeks' time we'll comply with the same.
No, you are
We'll
saying
take
it
steps for compliance of the office objections in the writ appeal.
was stated by learned additional government advocate Mr. Shekhar that writ appeal number 1705 of 24 is filed. In that view, it is, he further stated that the office of objections shall be complied with within the time which may be granted by the court. Also, 3 weeks' time is granted, within which the office of objections will be complied with, and the appropriate orders will be sought from the competent court in the appeal, failing which the respondent shall be liable to comply with the orders in question. Also, orders and direction in question. Stand over to let it go after vacation. Or 23rd April.
Number 41.
My lords, in this OSA 20 of 2024 has been.
Pardon?
My lords, this is with regard to the directions given in the company application with regard to the acquisition of NGF land, my lords. Nearly 29 crores had to be given. So OSA 20 of 2024 has been preferred as against the said order.
Before this court.
It's a virginal side appeal before this court only, madam.
They have not informed me, Melons. This is the second round of litigation and also second round of contempt proceedings.
Find out 24th April.
Number 42, to Srikant MP.
OSA 20.
Complaint. No reply is filed, my lords.
My lords will be filing the compliance affidavit now.
Give copy.
We are given the endorsement, my lords, for want of documents. We are unable to give the permission, my lord. Page 8 of our affidavit, my lord. Sorry, my lords, page 6, my lords, annexure R1.
What does it say?
My lords, at the last column, my lords, the directions of the writ petition order is noted, and we are given that society registration copy incomplete, land lease or rented, then society registration copy should be submitted, building completion certificate by local authority bodies, land conversion documents. For want of these documents, we are unable to give permission for running of the school.
Lords,
Annexure R1, my lords.
Yes, R1.
At the bottom column, my lords.
Proposal is rejected.
Yes, my lord.
Your lordship.
For want of submission of
Your
these
lordship may
documents.
kindly see, this is the exact, my lord's replica of, my lord, the endorsement which is quashed by the learned single judge. If your lordships kindly have a look at, my lord's page number 89, my lord's annexure M. Identical endorsement, welfare consideration before the learned single judge. Quashed and, my lord's directed to reconsider. Identical endorsement, my lords.
In a writ petition.
Yes, my lord.
File a writ petition. That is.
My lord, the difficulty is very same endorsement is quashed.
And it is a different, same endorsement.
My lord's identical endorsement, date is different. Date, my lord, the learned single judge.
Is it self-same endorsement is set aside? Or in a different case, similar endorsement, what?
No, very same case, my lord's exactly same, my lord's endorsement. Very same contentions were raised, negatived by the learned single judge.
So
Lord,
the-
your lords may kindly have, lords, bear with me for a moment.
Where is
Lords.
that order? Let us.
Page number 89, my lords, is the earlier endorsement, my lords, in my petition. The same is quashed, my lords, very same, my lords, reasoning assigned. My lords, the learned single church, after considering, my lords, passes the order. If lords kindly have a look at, my lord, the order passed. My lord, at 123, my lords.
You also not supplying the documents.
No, that is not right. My lords, I have. If lords kindly see, my lords, let the order be, my lords, for a moment, you lords may bear with me, my lord. Order, my lords, at 123 is passed by the learned single judge. My lords, after consideration at para 6, my lords, 126. It is quashed. And my lords, at small Roman 3, the concerned response are directed to reconsider the application at Annex K dated 14/3/24, submitted by the petitioner and take appropriate decision, pass appropriate orders within direction of 4 weeks. The liberty is reserved in favor of the petitioner to submit additional pleadings documents which shall be considered by the respondent, who shall proceed further in accordance with law. In furtherance of that, my lords, I made a representation. Next document at 128. Except changing the date, my lords, everything remains as it is.
So he said the documents were considered.
My lords, I've gone through the documents, my lords. Lease deed, registered lease deed of 30 years is a compulsory document, my lords.
Not
You have asserted in the affidavit also
Not
that
given.
such documents not been produced,
No,
my
no,
lords.
my
The
lords, that was
compliance affidavit, if the recital is seen, for us to provide this permission, a 30-year registered lease deed should be there, my lords.
lords, I
So
can,
that the students admitted will have continuity in the education
lords,
system.
it's an
So we have
exist.
stated in our compliance affidavit, such registered lease deed is not forthcoming, my lord.
Lords, it was my specific contention that it's an old school where I wanted to
Para
have.
3 of the affidavit, my
One
lord.
second. I wanted to have additional classes. My lords, I also showed the provision which says, my lords, for earlier school, that stipulation is not applicable. I, my lords, extracted that, my lords, and made a representation, my lords, that is not even referred to.
What is page 8? In your reply? The endorsement. Part of the endorsement?
My lords, those are the enclosure details, my lords. At the last,
So they are given by them.
yes, my lords.
Then they have given this.
My lords, they say that it should be a registered lease deed, my lords. Para 3, we have given the explanation why we have issued annexure R1, my lords.
Is stated by you in this reply that these are documents not given. File a better affidavit.
Better affidavit, very much.
And
21st April, in order to enable learned advocate, Mr. Shekhar, learned additional government advocate, Shekhar, to file further affidavit, my lords, in support of his case.
Number 43, Mr. Devarajan.
Since I appear for accused, the permitted to file affidavit, not that complaints would be not within 3 months, not that where not that monetary benefits are paid. That affidavit is filed, not that within 3 months we'll pay the monetary benefits. The reason that he had retired, before that, not that imposing penalty, not where that he has transferred various divisions. He secured the report and he needs to be say that. operative portion 62, page number 62.
Yes, who appears for this? Why 3 months?
Devarajan,
Why 3 months?
That he has transferred various divisions. That we secure the report from all the divisions and that revise that pay scale from the beginning that we have
What
to pay
you are
that.
doing? The order was passed when?
That the order passed in the month of March 2020.
24. So 1 year. If the petitioner is satisfied, we have no objection. Let him come. Keep back.
number 44.
My lords,
Srinivas
I appear for the accused in this matter. My lords may grant 10 days time in this matter to file, to make the payment, my lords. This,
Senior Advocate Mr. Arun B.
I only advocate, my lords.
Mr. Arun B. appears for the respondent seeking time and seeks time to file the reply. Learned advocate for the petitioner is not present. Stand out. We'll go after vacation.
Please, my lords. In the meanwhile, I'll make payments, my
12th of June.
This is number 45, Mr. J. Prashant.
My lords,
I appear for
45,
the
46,
petitioner in this case,
47
my
are
lord.
connected, my lords. On 3/2/2025, we have issued the endorsement. We're
Nobody.
getting the same ready, my lords. We'll file
Yes,
it in the
madam, you are
registry.
appearing.
My lord, I appear for the petitioner in this case, 45, 46 and 47, my lord, serial number
Yes.
45.
So what was the direction?
My lord, I am withdrawing the petition. We have received the endorsement copy.
Learned advocate Miss so and so appears through video conferencing. Submits and states that since the endorsement is passed.
3/2/2025.
3/2/2025.
3rd of February 2020.
Dated 3rd of February 2025, there is a compliance. It marks compliance of the direction of learned single judge. Therefore, learned advocate petitioner wants to withdraw the contempt petition. Full stop. The compliance affidavit is also filed along with the endorsement is produced.
I'll file it in the registry, my lords. I need to. I'll sign and I'll give it to the court office. Just now I got
Which is taken on record, in which also the endorsement is produced. The petition does not survive, contempt petition does not survive, it is accordingly disposed of. Same order in 46,
Obliged, my
47,
lord.
45, 46 and 47.
Very much, my lords.
Yes.
Obliged, my lord.
Number 48, the KV Narasimhan.
Record the name.
My lord,
Record the name. Who is? Yes.
my lord, office objection in IA, only in respect of arraying as a party, my lord, we have mentioned accused number 2, wherein respond number 2 is a state, my lord, so we have mentioned it as accused number 2. Office objection may be overruled, my lord. Office objection may be overruled.
The office objection.
My lord, the state is a respond number 2, my lord. Accused number 1 is he has filed affidavit, my lord, stating that he is not the concerned authority. So we've made a impleading application, my lord, impleading accused number 2. Impleading accused number 2, we have filed application. The application is on that application, office objection has been raised.
You need to join party over there in the.
I have filed application. That application is.
Objections were issued as against respondent number 4 in the original writ petition, my lords. He was not made accused in the present contempt petition. Now they have made him as a A2, my lord.
Yes.
So if it is.
I'll
approved,
comply with office objection. Meantime, notice may be ordered.
Office objection is complied with by completing the necessary party with respond number 2 hearing.
Very much.
We have already filed application.
Or with the application is filed. Full stop. In that view, the contempt petition will be listed before the court along with the said application.
Very much.
On
Well,
22nd of.
it has been put up. It has been put up, my lord. That application has been put up.
It has
raised the office objection that we have not made them as accused number 3. We have made it accused number 2. Office objection has raised.
You understood. Now what next like? What did you?
Um,
And the application to implead him is filed. Yes.
Notice may be ordered against
What
the
is the
proposed
direction?
accused number.
What is the direction? Let us
Right.
learn a single.
Representation had to be considered my manner, my lords.
Notice to the respondents, including the newly added respondents, returnable on 9th of June.
Public.
Number 49,
APF for the accused number 1 in this matter.
Nisha, yes,
My
Kumar,
accused number 3 in
14%.
On the last occasion, minutes, there was a direction for us to apply for the minutes water connection from this accused number 2. Minutes, the very next day, that is 21st of January itself, minutes I have applied. That is filed along with the memo minutes on 3/2/2025. My application is minutes, page number 2. Translation is at page number 3.
So the petitioner wants to comply with which directions?
My lordship, if I may be allowed to make a submission.
20th of January 2025.
Where
there
are
is a-
they?
minutes.
7th.
Is past minutes, 7 minutes, that is passed in MFA, pending MFA.
7.
Very minutes, protection was given to the complainant. And direction was issued to me to let her go inside the house minutes by way of gate number 4 and 5. There are allegation that I was not allowing her to enter the house.
My lordship, if I'm allowed to make a submission. I'm the complainant herein and appearing through VC, my lordship, because I don't have the money. My husband is not paying me my maintenance, so I cannot travel to Bangalore to attend and be present before my lordship for this hearing. On the last occasion, that is on 20th of January, my lordship had passed an order directing the husband to file an application before the panchayat. Although the application has been filed, my lordship, the relevant documents have not been submitted. So till date, the application has not been approved by the panchayat office. That's what is being informed to me by the panchayat office. And unless the documents have been filed along with a fresh application, we cannot proceed further and give you the water connection. So if a fresh direction can be asked them to.
You are for number 1.
I accused number 1, please.
Husband.
Husband, please.
So she says that some documents are not filed for the purpose of water connection.
Minutes, I shall verify from the Gram Panchayat.
Please learn full stop. As per order dated, in the order dated 20th/1/25, it was observed that respondent number 1 shall file an application for restoration of water connection before the panchayat. In view of the earlier order passed on 1/10/24, today when the proceedings came up for consideration, learned party in person stated that though the application is filed, it is incomplete in the sense that the necessary documents are not provided to the panchayat. Full stop. Learned advocate Mr. So-and-so appearing for this one wants to take instructions. Full stop. Time is granted if the application for restoration of water connections submitted by respondent 1 to the panchayat is incomplete in any respect, before the next date, the same shall be, the requirements have been made with by the.
Please, and I shall
put upon 22nd of April.
Please, please.
Regarding panchayat, it is not a restoration, it is a fresh connection. There is no
Whatever.
connection, because the owner will not have borewell in the premises.
We do not know.
Yes.
Supply the water connection
And
without technicalities. When we say supply, restore, you do it. There is no distinction between restoration and supply.
Let them make an application.
Otherwise, we will be in difficulty.
Please, please.
If the applicants shall be completed before the next date, and the panchayat shall restorably supply the water connection forthwith.
Please.
Much obliged, my lordship.
Number 50, the Jeevan
Lords,
Kumar BS.
I appear for the petitioners, my lords, complainants, my lords. Accused number 1 and 2, whom the notice has been dispatched, are Deputy Commissioner and Tahsildar, my lords. The notice which has been dispatched is awaited.
Service is awaited.
Service is awaited to the Deputy Commissioner and Tahsildar, my lords. Since they are government officials, my lords, they are, government advocate could take notice on behalf of accused number 1 and 2, my lords.
The service of notice to this one and this one too is awaited. Put up on 12th of June.
So number 51, Mr. Anandram K.
I appear for the
Regarding maintainability
appellant.
with office objections.
Lord, the office has raised an objection, my lord, with regard to maintainability of the appeal. So this is an attachment order before, attachment before judgment order is, that is what is challenged, my lord. Operative portion is at page 33. The application, my lord, was filed by the plaintiff under order 38 rule 5. My lord, but the order is passed not only under 38.5, but also, my lord, order 38 rule 6. And attachment is ordered where I fail to, my lord, furnish security, my lord. So that is referable to order 38 rule 6.1. So insofar as order 38 rule 6 is concerned, my lord, 43 sub rule 1 Q, my lord. Not order 43. Or an appeal shall lie from the following orders under provisions of section 104.
Referring to Q.
Q, my lord. An order under rule 2, rule 3, or rule 6 of order 38.
What is rule 6?
My lord, rule 6 is attachment, my lord. Attachment before judgment. Kindly come to, my lord, order 38 rule 6. Attachment where cause not shown or security not furnished. Rule 5, my lords, is procedural, where, my lord, the court will direct me to show cause as to why I should not furnish security, or, my lord, to furnish security. If I fail to do so, my lord, under rule sub rule 6, rule 6, my lord, attachment is ordered.
45, 46.
Now here attachment is ordered, failing furnishing of security, attachment is ordered by the court. So, my lord, it comes under order 38 rule 6.1.
Where is the attachment order?
No, attachment order, my lord, is at page 33.
In the operative, where is that? Read it.
My lord, page 33, third para of the operative portion. If the defendants fail to furnish as ordered here above, the scheduled property shown in IA number 3 shall be attached.
So it is 38.6 or
6, my lord. So therefore, appeal is maintained.
the appeal, the office objection is postponed to be considered at the time of hearing of the.
Yes,
appeal.
no, there is
So the
one
office-
more office objection regarding court fees, my lord. The office is saying I have to pay court fees ad valorem, which is paid before the commercial OS.
And
This is an interlocutory application, my lord, so fixed court fee is paid. Under Schedule 2, Article 3, Subclause 3(1)(a).
So let me consider pending the consideration of the office objections. The appeal shall be listed on 21st.
Very well. For admission, of that.
We'll examine your contents and
Very well, very well. My lord, there are other
especially court fee, just about this we are convinced.
maintainability. Yes, there are a few judgments of, my lord, various high courts, Calcutta High Court and Bombay High Court.
Whatever is there, you remove.
Yes, my lord. Remaining office objections I will remove.
Rest of the office objection shall be, the office objection regarding court fee and the maintainability of the appeal is deferred to be considered, pending which the appeal shall be listed on 21st April. The other office objection shall be complied with for the next date.
Very deeply obliged.
52, 53 are urgent. Cell number 54. Mr. Sanjay
I'm
Krishna.
appearing for respond number 3 and 4, my lords. The last occasion, my lords,
75 also is connected. Arising out of same. 19th it is given. 75.
Please use.
18/6.
It is a writ appeal. Yes, delay is there, delay is gone down.
Delay is condoned, my lord. I have complied with the direction as. to
Delay is
the-
condoned.
Yes. I was directed to deposit 2 lakhs in legal service. That I have done and I have furnished the compliance also. my lord.
Now 54 is called, madam.
Lord, she's making submissions with regard to serial number 53.
Mine is 75, my lord, rising out of 54.
What about 53?
Same date may be.
So what is which matter to be taken? She is mentioning about 53.
53. 52, 53 and 75 are of same judgment. my lord.
So what do you want?
Mine is 75, same date may be given.
That is. No 54.
Public.
Delay of 106 is gone down.
Not yet condoned, my lord.
Who
yes, I have to file my objections, my lords. Respond number 3 and 4, my lords. I'll file my objections, my
Or
lords.
delay?
Please, and also to the main petition, my lords, main appeal. My lords, what has happened is we have taken physical possession. My lords, the appellant, they have challenged the learned single judge's order. My lords, it arises
Yep.
out of the final notification, my lords, where almost 867 acres of land was acquired by KADB. My lords, before the SLAO, the appellate categorically goes and consents for acquisition, my lords. Later on, they file a writ petition, my lords, that came to be dismissed. They have preferred an appeal against the same. My lords, I'll file my objections, my lords. 2 weeks time may be
May I
granted.
make one submission? Throughout the pendency of the writ petition, there was an order of stay of dispossession. They are now contending that despite the stay, they have taken possession before the, while the interim order was in operation. My lord, there is some urgency insofar as stay is concerned. I know that there is a delay, my lord, but let them
Delay-
not unnecessary,
What has
no, they have
happened
not taken,
common order, my lords. It is a common order. 3 writ petitions were passed.
Now be
Out-
clear, you want time to file
Please, my lords.
reply to delay or reply to main appeal?
Both, my lords, both.
Both can't be there.
My lords, I'll file to the delay application and also.
So file within by next week.
Please, my lords,
8th
I shall
March.
file.
grateful, obliged.
So which
Review petition 53 of 2024.
Appealing for the petitioner, my lord. My lords passed an order on 7th August 2024. Pursuant to that order, my lord, the petitioner has appeared for the third year examination. The results has been announced, but her result has been withheld. If she has qualified, my lord, she can write her fourth year examination, and she has completed her course also. And 15th is the date.
Completed fourth also.
Complete course she has MBBS course she has completed.
Total years are completed.
Yes, my lord, she has completed.
How many years? 4 years.
4 years.
My lords, I appear for the university, my lords. My humble apologies, my lords. I seek one day adjournment as senior is not feeling well. He has to contest this matter. So I seek one day time, my lords, adjournment. Since
my only difficulty is that, my lord.
We are told that we are assembled because some urgency.
Yes, my lord. 15th is the date on which the examination starts, my
but
lord.
anyhow, my lords, the matter is listed on 14th. One day, my lords, if the seniors contest this matter, as the issue is, my lords, by virtue of interim order, she has appeared for examinations. Now, from the date of the interim order, if you calculate, it doesn't count for 12 months, my lords, as per the course of
Now
study.
you want to get the declaration of the result of the third year.
Yes, my lord. And third year result is declared, my lord. And if she qualifies, she can write the examination on 15th, my lord.
We have no objections in announcing results, my lords. We'll announce the results,
That's much we want today.
but subsequently they're seeking for the appearance of upcoming exams.
My lord, if she qualifies, my lord, she.
We'll say subject to outcome of the.
Yes, my lord. Yes.
Grateful, my lords.
Any IA is filed today?
Yes, my lord. I have filed it on 28/11/2024, my lord.
Number?
One, my lord.
28th
November 2024.
Top 24.
My lords,
No, one of IA number 1. However,
Page number 5 of my application, my lord. That is the exam.
without that the victim of appearance of the petitioner in the said examination shall not create any right or equity in her favor, and the appearance in the examination as well as the result shall be subject to further orders which may be passed by the court at the time of final decision. Subject to further orders that may be passed by the court. Today it was stated that by learned advocate Madhukar Deshpande.
Yes,
for the applicant that she has already appeared in the third year
Yes.
MBBS examination. However, the university has not declared result.
Yes, ma'am.
In view of the pendency of the proceedings.
Yes, ma'am.
Full stop. The order dated 7/8/24 does not restrain the university from declaring the result.
we'll declare the results.
Therefore,
May I seek one request, my lords, if she is cleared the examination, she will be eligible for.
therefore, as it is rightly submitted by learned advocate Mr. So and so appearing in the university, that the result of the applicant petitioner in respect of the third year MBBS examination shall be declared within on or before 15th.
My lord, 15th is the date.
Today, immediately, forthwith.
Yes, ma'am.
Forthwith, full stop. It was the prayer in the interim application is to permit the petitioner to appear in the fourth
Yes, ma'am.
MBBS examination, which commences
15th of March. ma'am.
15th of March, full stop. In view that the petitioner has appeared in the third MBBS and her result is to be declared as directed today, immediately and forthwith, comma. The court is of the view that she should be permitted in the fourth year examination, provided she clears.
Yes,
the
ma'am. Third year
Third
examination.
year, full stop.
My lord.
Petitions mentioned in order dated 7/8/24 about, it is clarified that the appearance of the, that if the petitioner is to appear in the, if the petitioner is to appear in the fourth year examination, it shall not create any right of
Right.
equity.
Without insisting for the order copy, let them give
Great,
effect.
we'll do it.
And that her appearance will be subject to further orders which may be passed. Also, without waiting for the copy of the order, irrespective of the copy of the order, irrespective of the copy of the order, comma, university is directed to permit the petitioner to appear in the examination commencing from 5th or 15th March, provided the petitioner passes in the
Third year.
Will be available, the copy will be available, but
Yes.
still.
Much
So
obliged.
IA is disposed of.
Yes, I,
That application is allowed and disposed of in the above terms.
Okay.
Numbers 75, 76, 77. 74. Office of Assistance will be removed within 3 weeks from today, failing which the appeal, whatever it is, appeal or petition, shall stand separate orders. This means without reference to, automatically without reference to our order of the court. And same order in 72 and 73, but they 4 weeks.
Pass over matter, seal number 43. So Devraj N.
You have a complaint, sorry, Manoj, sir, could not be present in the morning. But now they have filed an affidavit, Manoj, stating that they want 3 months' time, Manoj, to comply the order. This order was passed, Manoj, as per Annexure G, page 49. Manoj, may come to page 62, Manoj. Order of penalty, Manoj, has been modified. Page 62, Manoj. Writ petition is allowed in part. The order of penalty imposed by the respondent number 3 as per Annexure.
Now they are saying that within 3 months.
Yeah, for the accusation.
So let the matter be pending. It may be taken up in the first week of June, Manoj.
No, we will say that.
Liberty may be granted, Manoj.
On a single judge by judgment and order dated 13th March 24, allowing the petition in part, set aside the modified the order of penalty passed by Respondent 3 to stop from the penalty which was imposed to be withholding of increments, 4 increments with cumulative effect, comma, modified penalty of reduction without it was substituted. Our respondents were incumbent. Respondents were liable to pay to the petitioner the differential benefit arising out of modification of the penalty. It is for the said non-compliance paragraph. The contempt petition was filed. Today, when the petition comes up for consideration, affidavit is filed by the respondent in which it is clearly stated that the benefit arising out of the order of modification of lawless modification penalty passed by the lawless single judge shall be paid within 3 months. 2 months, full stop. The court finds that the 3 months time is the judge passed order almost 1 year back. In that view, it is directed that the compliance of the order by making payment of the benefits of the petitioner shall be done within 2 months from today. Full stop. Failing with the respondent will be exposed to the aggravated form of contempt. This petition is disposed of.
Till number 92, sir, withdrawal of writ petition, then Nataraj Ballad.
Nobody is present. Withdraw figures on record of this petition. Figures on record of this petition, memo of withdrawal dated 13 to 25, signed by the petitioners, learned editor of the petitioner. Which reads there than the court, here it is. The petition is dismissed as withdrawn with observation that the proposed comprehensive petition intended to be filed by the petitioner shall remain, shall be with observation that this court does not express any opinion on the maintainability or merits of the proposed new petition.
Case number 93, Mr. Vijay Kumar.
In this matter. On the last occasion, Lord, the government have filed compliance affidavit. Contempt we have effected, but it is partially complied, Lord. Just the
On
order
10th of this month, at 8,55,409 was credited, my lords.
Yes, my Lord. That I am not
Day before
disputing.
yesterday.
That I am not disputing, but still it is a partially, they have complied the order of the division bench of this order. Kindly come to page 27 for a moment, Lord. 27, Roman 4, which says, Lords, with 6% interest.
So it is refunded?
The amount primary
Roman
amount
4, 855,479 has been done. With regard to 6% interest, it's not reflected, my lords. I shall get
also
instructions on the further
Roman
amount.
5 also may kindly be seen, Lord. There is a
Only interest
cost-
part remains.
Interest and
part and the cost
25%, 25,000 cost, my lords.
20, that is not paid.
that is not paid.
We'll do that also.
We'll do it up for 10th of June.
Very much.
Shall we record that part of the order will complete?
Very much, my lords. On the
Learned.
8,55,479, my lords.
Is paid.
Paid.
Yes, Lord. That
Dated
I have
the-
no objections. for
8
that.
lakh so and so it is there. Is already been paid. What remains to be paid is the interest and the cost. Full stop.
Interest and the cost remains.
Learned paragraph, learned additional government advocate, Mr. Shekhar states in this regard that the remainder part of the compliance shall be obtained from the competent, shall be done by the competent authorities before the next date,
Very much,
on 11th June.
very much.
May I request, would it be, Lord, before vacation so that, Lord, retired employee, Lord.
Substantial parts been done. my lord.
2009.
11th of June.
8 lakhs you got. what?
Yes.
If nothing is paid, we would have kept beyond this side of the. Yes, next.
This is number 94, Mr. Murthy K.
For the appearance, notice was awaiting in the response number 8 to 14 minutes.
Services to be awaited. Serial number 94, since this services on the respondents is not effected so far and the same is awaited, the matter may be listed, matter shall be listed on 19th June.
This is number 95, Mr. Prasad Hegde.
So delay of 83 days.
Memo for petition for the third respondent. In this manner, the writ petition manner, we had taken up a paper publication. So far as the third respondent concerns, my lord, we have filed a memo for deletion for the reasons, my lord, before the Lawrence single judge. The notice which went to him did not serve, and therefore, my lord, we had taken out a paper publication. In spite of service of paper notification, my lord, none of them appeared. And also we do not know the LRs of them. Even LRs did not appear before them. And therefore, my lord, since he's dead, my lord, we have made an application or memo for deletion of third respondent, my lord.
May I submit, my lord, in respect of respondent number 3, the notice was taken out, my lord, before learned single judge through paper publication. Now I have information with regard to the details of legal representative of respondent number 3, who has filed a suit before the civil court. His name is B.K. Ramakrishna Reddy. I'll furnish the details to my learned friend. They could take appropriate steps to bring the legal representatives of respondent number 3 on record, because the allotment made in favor of respondent number 3 is under question. Therefore, he is either the respondent number 3, since he is no more, but his legal representatives may be necessary parties to these proceedings. I'll furnish the details to my friend.
So far, they have not served, even before the single judge, this information was not served upon us. If you serve it, we can take steps for them.
I'll furnish right now, side.
Law and order with the respondent states that we'll be furnishing by tomorrow the details of the heirs and legal representatives of the deceased respondent 3. Full stop. In response, law and order advocate Mr. So for the viewer for appellant.
Appellant.
Stated before they get that upon receipt of the information as above, the necessary steps will be taken to bring the heirs on record.
I know the details of one heir, only one of the legal heir, I know, because he has filed a suit. I'll furnish that detail. Please.
Kindly fix some date next week, I will make an application.
When do you want?
Next week,
Next 2:30. File application and get it.
File application.
Once you file the application, mention will permit you.
So 96 is adjourned. Number 97. Venkatesh Somareddy.
My lord, in this, my lord, the additional chief secretary, my lord, has initiated action. My lord, this matter pertains to respondent number 4, Panchayat, which owns 47 shops, my lord, and some vacant space. My lord, the tenancy rights have not been auctioned so far. Tenants have remained there, my lord, paying the old rents. My lord, and the rents also have not been revised. My lord, the additional chief secretary has written to the chief executive officer, my lord, to initiate action and to see, my lord, that auction is being conducted. So if my lord could grant me some more time, then along with that, I'll file a report, my lord.
My lord, we are contemplating the auction within short time.
My lord, yes, the additional chief secretary has written the chief executive officer, the executive officer, and then to the PDO.
Respondent number 4 is a Gram Panchayat in the present case. Since 3 decades, shops have never been auctioned, and it is given to their own members. And the relatives of the members. This is one aspect. Now, not only respondent number 4, but throughout the state, my lords, the prayer number 1, my lord, lost.
Constructed by Panchayat.
Please, my lord, let them.
Shops are constructed by Panchayat.
Yes, and the premises owned by the Panchayat. In the present case, there are 47 shops, 20 rupees to 100, 200. We will rectify it in future. That's what they say.
My lord, may I make one
my lord, my
submission?
prayer is.
I'm for the, Lord, I'm for the impleading applicant. I filed an application. But no doubt it is true that there are 47 lakhs, my lord, which are owned by the Panchayat. There are total 47 lakh shops as averred by the petitioner himself.
Shops, not
Lord, I have filed impleading application with respect to, my lord, 2 shops. Not even prior to the Grama Panchayat Act 1993, well, 2 shops were granted in favor of the impleading applicants when the Mandal Panchayat was in existence. But we are not in possession of the property as licensees or tenants. We are in possession of the property as grantees made by the Mandal Panchayat. there is no rents are being paid, and what was it was only shop, and we are that is 8 into 25.
Very sorry. Leave it.
One by one, you can dictate the order. The case of the public interest petitioner is that Respondent 4 Anandapuram Gram Panchayat has bartered the shops without auction, which are constructed by them. It is the case that the public properties could not have been given in a clandestine way to the allottees, and that the allotment should have been by the process of auction only. Paragraph. Responding to the grievance, paragraph. Learned additional advocate, additional government advocates in Nilo Bharat stated that the issue is under consideration at the secretariat level by the government, and that appropriate decision shall be taken within 4 weeks. Within 4 weeks.
Have it and I'll make
And
a
the same
submission.
shall be placed on record of the petition. Full stop. You say that we are going to conduct the auction, then we'll, because
Well-
no LOT or priority here. Beyond that, we will not be able to. We are telling it very clearly.
I bow down, my
I am
lord.
the impleading applicant.
Enough.
Please, please.
I am for the impleading applicant, but I am appearing for some of the allottees occupants.
And decisions shall be taken expeditiously. It is directed that the report and the decision shall be placed on record of the court within
6 weeks, Madam. 6 weeks.
6 weeks, on or before 21st April.
Please. May I add
Lord,
1 second, my lord, sir? My lords, the prayer. Now, my lords have dictated. My lords, the order for respond number 4, my lords. Now, throughout the state, it is so, my lords. Your lords may kindly direct
That
them.
will later on.
As my lord, please, please, please.
All other issues and the prayers, including the case of the impleading applicant, that the grant to the impleading applicants Was by way of
It is granted by the Mandal Panchayat prior to the village.
the
Panchayat.
allotment of the shop
Gram Panchayat.
was by a valid grant will be
Valid.
examined in the subsequent stages of hearing. Also.
My lord, with the writ petition pending, my lord, then because some of the tenants have filed a writ petition before the learned single judge.
We'll see all. At first you decide on principle what you are supposed to.
Very well.
Please. We are grateful.
Obliged.
So on 21st, when the matter comes up on board, you must be having report on record.
Yes, my lord. then.
But in the meanwhile, my lord,
Please.
certain office objections on impleading application, I may permitted to remove the office objections.
The impleading applicant in IA number so and so shall remove the office objections in the IA before the next day.
Please.
Number 56. Mr. Malaya MR. 56.
The respondent number 1, my lords.
Nobody is there.
Malaya.
What is the subject matter?
My
Any
lords,
Any
respondent,
urgency?
my lords, respondent number 1 here was a contractor, my lords.
Hmm.
He had been given, he had won the tender for the construction of educational buildings in the educational institution, my lords. And there was a dispute regarding to the compensation, my lords.
This is writ appeal.
Yes, my lords.
Against which order?
My lords, the petitioners herein, they had sought,
Against which order?
that's what, my lords, they had sought an appeal.
For the order. Because where is the order of learned single judge?
My lords, it's at page number 21, my lords.
21.
It's the order of the learned single judge, my lords.
Yes.
My lords,
22nd of April. Since learned advocate, the appellant was not present. Was not present.
So 57 is urgent. Number 58.
Which was disposed of in 99 itself, my lords. There is an impleading application who has been filed. There is an office objection on that ground. On a disposed of petition, and impleading application is not maintainable. And there is an order also of this court, my lords, that only on the request of the deputy commissioner or the petitioner, the case may be recalled only for the purpose of withdrawal of certain monies which are deposited. The impleading application has been put up, but it's not maintainable, my lords.
I appear for the petitioner, my lord.
So what is the application by which it is now again?
Okay.
My lords, the applicant claims that the land now which is being allotted to build the primary health center is in his possession.
I appear for the petitioner in this matter.
He is the and he has challenged that before not been coming also, my lords.
Time permits. Any urgency?
No urgency.
No, urgency is there, my lord, because there's another writ petition, my lord. Mr. Ravi Shankar was there in the last occasion. My learned friend was not there, my lord, and therefore it was urgent.
The petitioner should not have a difficulty because the impleading applicants
Not the
are
petitioner,
not here.
but Mr. Ravi Shankar was there in the court minute on the last occasion. Your
You
lordship
are
was
for,
just hearing
you are
this.
for you are for petitioner,
I am for the petitioner, Mr. Ravi
Or im-
Shankar appeals for the impleading applicant.
but then let it go to 25th of April.
Please.
April, after April. In front of it, great.
25th of April.
Please, Your Lordship.
25th
Sister-
April, my lords. It is great.
Number 59, Mr. N. Shankar Narayan Bhatt. 59.
Like
Shankar Narayan Bhatt.
My lord, I'll take notice for respondent number 4, my lord.
this is 2008.
Abhinay Whitey.
Who is for the
Abhinay Whitey.
eighth of, since nobody is present on behalf of the petitioner or applicant.
Number 60, Mr. Narendra Kumar, party in person.
My lords, I appear for the respondent competent authority, my lords. I seek for a short accommodation, my lords.
Let us see what is the matter. Immediately you are asking for time.
My lords,
Immediately upon calling out of the matter, you are asking for time. As if you are offering.
some personal inconvenience with the senior, my lords, that's why.
What is the matter?
My lord, my lord, may I submit? May I submit, my lord?
If you want to submit, submit.
My lord, I had filed a memo on 23/7/24 saying that respondent number 12's property has been encroached upon, that, my lord. And the other respondents also, progress is very slow, my lord. Other respondents also, respondent number 11 to 19 and 25 to 34. The progress of but 1 lakh depositors are waiting for the refund, my lord. Some people have got partial refund, but most of the funds are being held up for no reason, my lord. Auctions are not happening. Some stay orders are there, they're not being vacated, my lord.
scheme, my lord, wherein, my lord, they were promised halal income. And my lord, the depositors, my lord, whatever money they had by way of savings, my lord, had invested the amount, my lord, and thereafter, my lord, they have been cheated.
There are about 19 such companies, my lord. 1 lakh depositors, 5,000 crores they have lost, my lord. All savings, many are senior citizens, my lord. They're waiting for last 7 years to get some money out of them.
You're one of them?
Pardon? No, my lord.
Cases.
My lord, the competent authority has already been appointed, my lord, and and some of the properties have also, amount has also been refunded. It's,
My lord, all that only because of.
my lord, he'll have to submit, my lord.
Sir is my senior, my lord.
Which party? Sir?
My lord, respondent number 1 to 4, competent authority, my lord.
1 to 4.
So I appeal for the competent authority, please, my lord.
Who appears? 1 to 4 is government.
No, sir.
Yes,
You appear
I appeal for the
my lord, he's appearing on VC, my lord.
But on
no,
whose
sir,
behalf?
some personal inconvenience. May I pray for tomorrow, please, my lord? Anytime convenient to the honorable court, please, my lord.
On whose behalf?
No, sir, on behalf of competent authority, please, my lord. On behalf of
appear.
competent authority, please, my lord.
Pardon?
Is appearing above respondent number 35, who happens to be the head of all the other Ponzi companies. He
Competent authority, specified officer.
yes, my lord. He's
Under
a
the
special officer, my lord.
Karnataka.
First, may I pray for a short accommodation, please, my lord.
What is?
Protection of interest of the report to him.
As much as we can.
Contempt.
Contempt was disposed, my lord.
You are there.
Yes, my lord. I've been appearing last 5 years, my lord.
So bring out that if possible. Learn for this 135, 6 times 10 or 2. When shall we keep?
My lord, there is another 60.2, my lord. They have not submitted any action taken report last 2 years, my lord. There's another Ponzi company, my lord. They have not since any given any action taken report. My lord.
Not 7th. Some reply should be.
Please, my lord. Action taken report, my lord.
Whatever they want to find.
Serial number 91 in order petitioner, appellant, my lords. Lords, office objection is, my lords, non-filing of, my lords, the photographs, color photographs which I have produced before the learned single judge. Lords, those photographs are not available, my lords, because those photos are obtained.
Objection regarding color photographs is dispensed with. However, they need black and white photographs.
Are produced, my lords, already produced.
Serial number
May
73, my lord.
make one more request, my
Appeal
lords.
shall be listed. Appeal is there. What is it? Appeal.
Lord, serial number.
Appellant, my lords, appellant.
Appeal is there.
Please, let appeal.
Shall be listed on?
Monday, my lords.
No, not.
Lords, they are demolishing the, my lords, my existing compound wall. Lords, the issue before the learned single judge was, my lords, with regard to, my lords, sanctioning of certain funds by the government to put up compound wall. It's already in existence.
24.
Please.
Serial number
80, my lord. Same photographs have been another sector. The rest copies have been produced.
Same order.
Order is in past execution.
80, my lord.
Monday, my lord.
Serial number 80, my
Serial
lord.
number 73, my lord.
This objection is some
Tuesday,
2
my lord.
pages of the gift deed are not there. I have produced the whole gift deed only. Yes, my lord.
Serial
80,
number
my lord.
73, my lord.
80.
Kindly next week, my
The
lord.
subject matter of the arbitration is the apartment, my lords. They have alienated it into a gift deed. Now they may alienate it, my lords. Hence,
So you're not.
Seven
there
zero.
when it is called.
sorry, my lord.
79.
Get back
80, my lord.
80.
80, my lord. 80. The objection is page number 84 and 85 is missing. I have produced the whole gift deed itself, my lords, which includes page number 84 and 85.
So 80 office objections are time being dispensed with. The MFS will be listed on
Monday, my lords, if possible.
26.
Serial number 73, my lord.
Great.
Tuesday, my lord.
Serial number 82, my
My lord, serial number 79. Sir, oh, can't help it.